injunction simpliciter of the year 2004. In the year 2024, when the suit is at its fag end, and the application of a third party under Order 1, Rule 12 has been added.
Yes.
Lordship, urgency is called the Lordship execution.
Last chance has been given, my lord, to file.
What is the next date?
In the next month, my lord, exactly.
Please ascertain that. Yes.
Preparation of the expeditious here.
Please come on Wednesday.
For upgradation.
Mentioning for inclusion, please come on Wednesday.
For
Don't
upgradation.
mention any matter unless you can wait till Wednesday.
Next date has been, my lord, may I allow to mention
Lord,
one matter, my lord?
Mentioning
Next
for
date has been fixed on 13th, 30,
13th of
April, my lord. 30.
30.
Yes, my lord.
For what?
For hearing of an application. This is
What
my
is the
application
nature of
for
the application?
expeditious disposal of the matter, my lord.
No urgency. Yes.
Your Lordship, for upgradation, your Lordship, the revision application.
Please come on Wednesday.
Lordship, delivery of position was fixed, your Lordship. Verification was done in the execution court, your Lordship.
Yes, nothing will
For
happen. Yes.
extension of item number 254
When it is expiring?
30th of April.
30th. And over the slip.
Item number 254 of your Lordship's slip, the urgency is, my lord, the lower court fixed the date on 30th April, on which day they will proceed, unless and until I get an order of stay.
Nothing will happen.
Then-
Yes.
Difficulties, my lord, there is a
Yes.
stay, my lord, that-
Visitation, right, my lord, despite your lordship's order on 10th of March, the matter is not appearing in the list. Once I have been permitted to see my child, thereafter, my lord, the mother has
10th of
completely-
March.
10th of March, my lord, had passed an order.
Yes.
To be
When it was
waiting for the-
directed to appear.
Lord, next week, just after week, after that next week.
The
Lord, so this,
Extension for the inclusion in the list.
Can you not wait till Wednesday?
my lord, may I permit to mention extension of interim order, right?
When it is expiring?
30th, my lord.
Hand over the slip.
My lord, my lord,
My lord, it's a restoration application, my lord.
Please mention on Wednesday.
my lord, permission to mention one matter, my lord. This matter was appearing in your Lordship list on 24th April, my lord. I've taken a not to an adjournment on that date. After that, the matter is not appearing, my lord.
It will appear.
My lord,
Yes. Yes, Mr.
my lord,
Chatterjee.
there is a serious urgency, my lord, in this matter,
Yes.
my lord.
By way of filing a civil revision against an order of injunction where there is no pecuniary jurisdiction, 1,65,000.
Injunction, civil division.
Yes, my lord. And the court has entertained an my entire construction has stopped. Lord, I have tried my level best.
So you are the opposite party.
I'm here for the petition, my lord. Revision in the trial court.
Yes. So injunction order has been passed against that civil division.
Revision
Good.
passed.
I was under the impression against injunction. That is why I am saying.
Now, and even the suit valuation, my lord, is 1,65,000 cannot be, my lord, filed before the civil judge junior division. Filed before the junior.
Take that point, Mr. Chatterjee.
We've done everything possible, my lord, but for some reason just can't get it heard.
So can you
And
not
my
mention on Wednesday? You can
entire-
wait till Wednesday, Mr.
Have
Chatterjee.
tried, my lord. If your lordship
Please.
made appear on Wednesday, I'm praying for that. Because, my lord, every day I'm losing, my lord, a lot of money.
Please, because please ask your juniors to mention on Wednesday.
So I'll just remind your lordship, my lord, on Wednesday, my lord, that this
My
is,
lord.
Yes.
this is
May I?
My lord, this matter is dismissed as withdrawn on 26 March 2025, but in the order, there is a typographical error which was
Hand over the slip. Yes.
May I have your kind leave to mention for upgradation, your Lordship?
corrected by order dated by 22/4/2025, but the order is not sent back to the department, my lord. I'm not able to get back
Hand
the.
over the slip. Yes.
Yes, mean that the urgency is that this, the next date is just tomorrow, your Lordship, in the suit which has been set for final hearing. I am the defendant. My DW2, who is over 90 years, his witness by commission has been rejected by the trial court, your Lordship.
Hand over the slip.
Grateful, your Lordship.
Just call the list. Yes, Mr. Subba.
Lordship, this matter is already appearing in the monthly list, your lordship.
For upgradation,
Yes,
please mention on Wednesday. Yes, call the
May I
list.
have your kind leave to mention?
Sir, can you not wait till Wednesday?
My lord, there is
So urgent.
urgency is there, my lord. The next
You cannot
date
wait
on,
till Wednesday.
my lord, the next date is on 2nd May, my lord.
Yes, please mention on Wednesday. Yes, call the list.
1, 2, 3.
These matters, my lord, I had mentioned my lord, on the last day.
I'm appearing only in item number 1.
You are appearing in item number 1. The separate parties. Why it's with why it
Well, I'll
has
tell you, lordship, why. Well, this is a perennial problem for a public body. By having several public premises, lots of proceeding under the Public Premises Unauthorized Occupants Act are pending in different courts, I mean the appeals. But the statute provides for a specified period. The statute provides that stay should be conditional. Now the problem is, number one, my lord, the adherence to the period to dispose of the appeals are not being, my lord, adhered to. And number two, my lord, the stays are being granted, my lord, at
Without imposing any condition.
no, conditions are being imposed where the claim is say 10 crores, the condition is paid 30,000 rupees per month, which is almost not a condition.
What is the order under challenge here?
Lord,
Expeditious disposal.
primarily, my lord, to maintain this kind of petition, my lord, we challenge our order, but finally, my lord, to be very honest, if your lordship may kindly take, my lord, page 90.
Expeditiously, it should be, your prayer is to dispose it of expeditiously. The appeal, PP appeal.
PP appeal within a certain period, number one. And number two, my lord, it should go down, my lord, as a sort of a direction which should, the learned courts below should apply in all cases. Because
Apply
your
in
lordship
all-
is the administrative superintendents also, supervisory jurisdiction also.
So it's a general direction, it may not, maybe what is the facts of that case? Because Mr. Dotto,
Proposal, only nothing else. Because the statute provides that it should be disposed of within a particular period. My lord, facts.
what is the stage of the appeal?
My
It's
lord,
ready for hearing.
ready for hearing long back, but
Now, what's the next date fixed in the appeal?
Lord, next date, when we came, my lord, the next date was 4th of May 2024. So 1 year back.
Yes.
So, oh, 17th of July.
Preponing may be a difficult thing. For that, I can give you leave to apply for
Sir,
preponing.
we would apply, but your lordship directs that the matter be disposed of within a particular period from the day I apply.
Yes, Mr. Mukherjee, what?
Hi.
You don't have any objection?
Mr. Dotto is appearing.
That is why you are not objecting.
For expeditious disposal, kindly remember, when we are appearing for expeditious disposal, you are asking the junior to move.
Oh, তুই এইটা বলতে চাইছিস?
General direction.
Yes, Mr. Dotto, that is the,
Yes, that is a valid point. Definitely a valid point.
do you have the statute with you?
Yes.
Okay, public. A judgment in the earlier matter also.
Also, I am handing over to you, sir.
But we have your lordship's order. But please take note section 9, subsection 4. The judgment are there? But this is your lordship's earlier order. কোথায় দিয়েছিস? আচ্ছা। নে।
Within 1 month from the date of filing of the appeal.
That is the
In eviction, should and matrimonial should kindly remember.
All matters.
these
That
are
is why
summary
I
proceedings.
think when Mr. Dotto mentioned, I told him this thing.
Yes.
That in most
Now-
of the
now
statutes, there is a time frame. But
But let us make an endeavor, my lord.
yes, and
But please consider, my lord, giving a general direction.
where is, have you got the Supreme Court judgment?
Yes. Yes. Bandi judgment we have.
I think there, in that there was a direction.
Please take note paragraph.
Mr. Mukherjee, do you have any objection if an order is passed on in the to be mentioned stage?
Sorry.
It's appearing under the heading to be mentioned. Do you have any objection in final disposal at the to be mentioned stage? Then I have to fix a date. Then I have to fix a date.
Item
তো
number
বলো এসে এগিয়ে এসে বলো।
I am in item
Ah.
number 2, Lordship. Mr. Basu, senior advocate, Millard, appearing on behalf of Millard on behalf of
Which is Mr. Shoptanshu Basu.
Yes, yes, Lord.
Where is he?
Millard, he is not Millard.
I've seen him in the
Yes,
in
yes.
rule number 1.
Lordship, if
So he has come.
your Lordship, Millard, kindly we fix another date, Millard, for hearing us. I am Millard in, and Millard, both the 3 matters, Millard, were Millard heard together, Lordship. Please.
3 matters?
Yes, yes.
না, সেটা বলছেন, সেটা জজটা
হ্যাঁ।
বলছেন। তোর অসুবিধা থাকলে বল না, জজটা ডেট ফিক্স করবে, বলছেন তো বল, বল ভালো করে বল।
Yes, Lordship, if your Lordship kindly fix another
Awesome.
date, Lordship.
Then kindly keep it sometime this week. But tomorrow.
I'm keeping it tomorrow under the heading for orders.
অসুবিধা নেই তো।
Tomorrow you have difficulty.
My lord, I have not been instructed that Mr. Basu is available and tomorrow is.
Mr. Basu tomorrow will not be available.
I don't know, Lord.
I will not allow Mr. Datta to move, and I will also not allow Mr. Bhatt to move.
Yes, yes.
You can move.
Lordship fix me, Lord, any day, Lordship as
Tomorrow.
convenient.
কালকে দিয়ে দাও, কালকে দিয়ে দাও।
In connection with other expeditious, may I hand over the slip, my lord? In connection with other expeditious disposal matter, may I hand over?
What expeditious disposal?
The disposal of the matter.
Yes. Mention on Wednesday. Mr. Datta mentioned on last Wednesday.
I'm grateful.
Please take back the book.
এই বইটা
অপোজিট পার্টি পিটিশনার তো উনি সব কটা
বইটা
জাজমেন্টটা ফাইলই না ওটা বাদ।
Mr. Mukherjee, all expeditious hearing matters was taken up. Entire monthly list.
Unfortunately, my matter was
That is a different thing.
supplementary list.
So I could understand why you made that submission, but all expeditious hearing matters in the monthly list was taken up.
No,
That bunch.
my matter was not within that bunch.
That is a different thing altogether.
I will mention on Wednesday, my lord.
Yes, call the next matter.
Item number 4.
That is the matter, my lord. Because I am vacating the decretal property today by 5 p.m.
Today by 5 p.m. you are vacating.
Only one, my lord, one thing.
My lord, information, my lord, in this way he is twisting.
My lord, I am
This is
not
the one-
twisting, my lord.
Today 5 p.m.
Today by 5 p.m. My lord, and I am on, my lord.
I'm keeping it to.
Yes, my lord. My lord, one.
I'm recording his submission.
Yes, my lord.
Today it is fixed for delivery of judgment of title appeal.
Yes.
My lord, so my lord, my single prayer, my lord, let the title appeal be dismissed as withdrawn.
Why, my lord?
What?
My lord,
He is
why?
saying why? My lord, kindly see.
My lord,
He
why
is
you
saying
do- My lord, I am.
in one breath he is saying today at by 5 p.m. he will vacate. On the other breath he is telling why.
The learned advocate appealing for the petitioner
My
submits.
lord.
Opposite party. Lord, I am for the petitioner. Lord, the interim order is expiring on 30th of April. Lord, the initial interim order was passed on 30th of April 2020.
What is the impugned order?
My lord, the impugned order challenging an order passed under section 24 of the Hindu Marriage Act. The husband has preferred this revisional application.
Yes.
So the impugned order has been stayed, provided that I am paying 20,000 per month.
What was the amount of alimony fixed?
My lord, 25,000 in the impugned order, 25,000 was given, and now I'm paying 20,000 per month. And an ad hoc payment of rupees 2 lakh has already been made, and I have filed my affidavit of compliance to that effect. My lord, in this matter, and there is a chance of amicable settlement. The compromise is going on.
I'd like to submit that as per my instructions, the amicable settlement talks have failed. And once that talks have failed, they have not made the 20,000 payment for the past month.
I shall,
They have not paid.
for
the
this,
last- for the,
I have
for
not
the
been
last one, they
communicated.
have not.
I
Sir,
have,
if you have not paid, no extension. Please come
Alright.
tomorrow.
Alright,
Not
wait.
today.
Wait,
Please
wait.
take instructions. If
Deeply.
you have not paid, no extension.
Grateful.
Please call the next matter.
But admitted area and admitted rate of rent by the defendant in his evidence under section 7(2) did not pay, Lord, therefore petition under section 7(2) is not maintainable. Lord Lordship, kindly look to the first order dated 23/8/2004. The failure of the defendant to deposit admitted area in compliance with the provision of 7(1).
No, this is the order.
Admission of the revisional application.
In view of the order passed.
Now, Lord, I can state
stands
it.
disposed of finally. How it has been disposed of?
Disposed of finally 7(2).
Directed to pay rent for such and such months. Directed to deposit.
That is not maintainable. Lord, only one thing I may draw your Lordship's kind attention. The first day, the matter when matter came up for hearing before Justice, Honorable Justice Raja Basu Chaudhary, Lordship directed to further give a notice to the
Nobody is appearing.
Nobody is appearing. Even thereafter, my Lord, I have served the copy in terms of the order of Honorable Justice Raja Basu Chaudhary. Now, my Lord, I straightway come to my short grievance. If 17(1) is not, first part is not complied with, then 7(2) is not maintainable.
Show me that how that
Yes,
that
Lordship,
point was
finally come to page
dealt with by
58.
deal on a trial.
Finally come to page 58. Then I shall come back to the
Page
58, my Lord.
58. What is that?
This is the deposition of the defendant petitioner in the application under 7(2).
Yes.
In clause, we have paid rent to the landlord up to September 2017. Objected to on the ground that there is a dispute with regard to landlord, that the last rent we paid to the landlord directly. Then, let's keep over, my Lord, 1, 2, 3 lines. It is a fact I have not paid any rent from October 2017 till the date of filing of this suit to the landlord. Besides making payment in court, I can produce those documents. Therefore, it is a fact that I have not paid rent from October 2017 till the date of
So
filing of
this
this.
was dealt with by the Lord trial judge. in
Now,
the
Lord,
order issue.
before that, your Lordship, kindly come to the application under section 17(1) and 2.
17 or 7?
7(1), 7(1) and 7(2).
Yes.
Lord, page, Lord.
Mr.
20
Banerjee, is there any dispute with regard to the rate of rent?
No, no dispute. That is why I am placing.
Yes.
Page 22, my Lord.
22, yes.
Page 22, my Lord. Dispute as to the rate of rent, nothing, no dispute. That is why I am placing.
Yes.
No dispute. Now, Lord, they wanted to deposit rent from September and October 2021.
September and October
2021. Now, Lord, he had
they are in the area since 2017.
2017, October.
No,
It's October.
no, deposited up to November, so from December 2017.
December 2017.
They are defaulters.
Yes.
Or they
Now,
are in
Lord,
arrears.
Now, Lord, they did not deposit. They deposited 1,500 per month according to the in 7(2). No dispute with regard to the rate of rent. Lordship, kindly come to the 7(2), page 24. No dispute as to the rate of rent.
But what is the rent claimed by you?
Rent claimed by me according to my plaint. Your Lordship, kindly come to my plaint at page 15, my Lord.
Yes.
Lord, paragraph 7, page 16.
5,000.
5,000.
They have not disputed this.
They have not disputed in section 7(1), 7(2).
What is the finding
Now,
of the trial judge?
Lordship, kindly come to the finding of the trial judge. Lord, paragraph 18, Lord, page 6. Paragraph 18, page 6. As per submission of the defendant, it paid rent of the suit premises to the previous landlord up to 2017, and thereafter it had been paying rent of the premises to the then plaintiff, Biplab Rai and Nilima Rai. But to prove the payment of rent to the since after October 2017, the defendant has failed to produce any document. Then your lordship kindly come to paragraph 20. Defendant submitted that the tenant under Milord, this is not required, Milord. He toward the bottom. Defendant has not disputed exhibit this atonement notice. Suit premises is also not disputed. Accordingly, relationship between landlord, plaintiff and defendant as landlord tenant is also undisputed. Now, Lord, your lordship, paragraph 22. Plaintiff have submitted that the defendant did not pay any rent for the suit property even since month of September 2012 until the end of year 2021. Thus, it had defaulted in payment of rent for this suit property 112 continuous months. Lord, then next page, your lordship kindly come to after few lines thereafter, but thereafter, in spite of being informed, exhibit 3, that the plaintiff had purchased this property, did not pay rent unto the new landlord, that is the plaintiff. Plaintiff in defendant in cross-examination has admitted that it has not paid any rent from October 2017 till the date of filing of the suit to the then present plaintiffs, and there is arrear in payment of rent, and it has not deposited this said rent in court as per law. The defendant appeared in the suit on 18/9/2021. On 5/10/2000, defendant filed application 712. By filing this application, defendant has expressed its number of 1 day delay. Even then, 1 day delay. Now, Lord, paragraph 25. There is nothing on record to suggest defendant under any dispute with regard to whom it shall remit the rent. Defendant knew the plaintiffs has become the new landlord of the suit premises. Hence, it could definitely pay the rent of the suit premises unto the plaintiff at the rate it was paying.
But Mr. Banerjee, only one thing, it's appearing as for extension of interim order. They are not appearing, so.
Lord, both the days we have service, two affidavit of service.
Mr. Banerjee, extension is not a problem. But can I dispose it of finally? Because
Lord, I have given a notice.
Notice for extension.
No notice for that. After that notice has been given saying in terms of the order of this court.
Yes, in terms of the order, today it's appearing under the heading extension of interim order. Can I dispose it of finally? That is the difficulty. That is the difficulty. I'm fixing it.
I shall again serve a notice, Lordship.
But I beg to appear on behalf of the opposite party number 1.
Yes.
My lord, who is the contesting party?
I am the petitioner led by Mr. Honorable Lordship. I am praying for extension as
The
well as
interim order
reading-
has expired last on
as
December
well as
2024. Your
reinforcement.
lordship kindly dispose of, if it comes to your lordship, can dispose of. My lord, order 7, rule 11 application filed after framing of issues. My lord, I stand here. Order 14, rule 2 application filed after framing of issues. My lord, saying that one of the prayer is barred by law, that has been rejected by the court below.
We have come up with challenging the said order in our revisional application.
Yes.
And I have another.
You are led by whom?
I am led by Mr. Honorable Lordship. in this
Where is
matter.
he?
Lordship, today he is on his left, Lordship.
All right, pass over. Yes, next.
Much.
8.
Item number 8, Your Lordship, I am for the petition.
My lord, I am for the opposite parties.
Yes.
So the interim order was passed, Your Lordship, on 11th March. And Your Lordship, it will expire, Your Lordship, till the, rather, Your Lordship, it subsisting till the end of April 2025. That's why, Your Lordship, I mentioned the matter. And this is an affidavit of service. Some of the parties have already refused.
What was the application under 151 for?
Application under section 151, yes, Lordship, was for recalling of an order where my PW1's, Your Lordship, cross-examination, Your Lordship, has been closed. Immediately
Yes, so
thereafter.
that application has to be taken up.
Sorry.
But, Your Lordship, the trial was at the stage of preliminary hearing.
No, but they filed an application under 151 that ought to have been taken up and considered this way or that way. Keeping that, can it be done?
The trial court has to rejected that application.
Why? Keeping pending means everything gone.
But
They have paid for recalling of that order by which their cross-examination was closed.
But Your Lordship will kindly consider one aspect of the matter. It was at the stage of preliminary hearing.
It could have been rejected. Sir, I accept your submission. That application could have been rejected on that ground. But keeping that application pending if the suit proceeds, what happens?
But
the court is at liberty to reject that. Let the court reject that application, saying these grounds.
My lord, they ought to have filed one application taking up the PH vote.
That is a
That procedure was not followed.
Is a technicality. If you want, I can direct the on the next date to take up the hearing of the application under section 151 of the Code of Civil Procedure and to dispose of.
Let this application be disposed of with
Yes,
the
yes.
direction.
Yes.
With the
So what is the next date fixed?
9 June. 9 June, Your Lordship, is the date fixed, Your Lordship, for filing certified copy
of this order.
of this order.
So I'm directing on 9th of June to take up the hearing under section 151 and to dispose it of.
Exactly.
Have you filed any objection to that?
Which,
151 application? You will be at liberty to file an objection in the meantime.
And without any observation from your lordship, it will be heard out by the trial court.
If I'm not making any observation, I will only direct that application. Since it was pending, I will direct the learned trial judge to consider that after giving you an opportunity to file a written objection. How soon can you file the written objection?
1 week time. Next to come here.
9 June.
9 June.
তার আগে করে দিন।
You file within a week. File a written objection within a week.
Within 2 weeks. Within 2 weeks.
2 days.
2 weeks.
Or 2 weeks.
ঠিক আছে।
One stood closed.
PW1 closed, PW2
They
started.
challenged that, and they also filed an application under 150.
Because they refused to proceed with the cross-examination. On their submission,
Yes, yes. That,
cross-examination was closed.
so that is the ground in 151. You contest that, let it be decided once for all. So I'm not deciding it on merits.
My lord, this same petition, same revision application. here.
No. This is the other revision. No. The earlier 144, have you given a copy?
I'm giving you a copy.
That is the, please come, the order dated 17th of January 2025 was challenged in that. देखिए दिन तो
17 January. Yeah, 17 January.
এখানে এই অর্ডারটা
হ্যাঁ, বুঝতে পেরেছি, দেখেছি।
17 January.
ওটা 38 ছিল।
ওটা 38 ছিল। আছে।
Yes, PW1 was closed and the other plaintiffs were directed to adduce. That order he has challenged in CO44. You have given him a copy.
I've given the copy.
Sir, you have seen that. Ashun.
Like these two revisional petition may be disposed of.
Yes. By a common order.
Yes.
By one. fix a definite
Sir,
timeline.
please use the microphone.
To fix a definite timeline
1 month from the next date.
for
please.
disposal of the suit.
No, my section
Mainly
10
because
application
the
is
suit
there.
of 10 years old.
So my section, last of all, only my
The
section 10
disposal of the
section.
I said after disposal of the interlocutory application, sir. Is it not an interlocutory application?
I'm grateful. Your Interim order take purpose. Interim order can extend also. That should stay as well.
I am for the defendant number 1 petitioner.
My lord, Mr. Subir Kumar Sharnal appears for the opposite party number 1, my lord. My lord, kindly, on his behalf, my lord, he has difficulty in this week, my lord, to appear in the matter. My lord, what I am.
Please use the microphone.
No, my lord.
Use the microphone.
No, my lord. In this matter, Mr. Subir Kumar Sharnal appears for the opposite party number 1, my lord. He has difficulty, my lord, in this week, my lord, because one matter is fixed before the division bench. That is a 32,000 teachers matter, my lord. That's why, my lord, kindly extend the interim order for a limited period and fix up the date for hearing, my lord, next.
My lord, it is their fair submission because, my lord, they are trying to continue with a frivolous suit. My lord, this is such a suit where, my lord, on the death of the representative of the plaintiff, my lord, the suit has been filed in the as a representative category. My lord, they are trying to carry on with a frivolous suit. My lord, on the death of the representative. My lord,
Mr. Mahato, this is the first day which is appearing. I am extending.
objection to that. I have no objection to that.
Fixing a date.
Kindly extend the interim order and fix a particular date, my lord, so that the matter may be disposed. Because my this suit is a frivolous suit. My lord, his suit has been filed in representative category. On his death, my lord, an application on order 22 rule 3 was filed. That has not been entertained.
This application, no, this matter is
this suit
appearing.
is otherwise, my lord.
Yes, yes, call the next matter.
I am appearing for the petitioner.
Yes, I am
appearing for the opposite party number 1 and 2. The interim order is still end of this month, my lord. Last occasion, my learned friend raised the question of the maintainability of the application arising out of the ad interim order of injunction, whether revision or suit is maintainable.
Yes, Lordship, I raised these 2 points.
Yes.
In the admission order, Lordship was granted liberty to the petitioner to edit my client as a opposite party. But in the misappeal, he not added as a party or the respondent.
Who has not been added?
My client was not added party respondent in the misappeal.
Why have you not
My
added him?
instruction they have also filed, my lord. They have also filed. My instruction is they have also filed the application for addition of party, my lord. This is
But why did you not include them?
this is my instruction. They have also taken steps, my lord. My lord, since my lord granted
No.
to
Is the complainant,
yes, my lord. That
so
is
he
true.
ought to have been included as the party. Why have you not included him as the party?
My lord, they have already taken steps, my lord. This
That
is
is
my
neither here nor there.
no.
you-
Here, lordships have granted me leave. That's why I have made the party, my lord. And after that, I have served the copy, my lord.
To that extent, I have no instruction, Lordship.
On the last occasion, they have also been amended. They have also added the party, my lord. They have also appeared in this suit,
Added,
my lord.
added a party.
Have you been added in miscellaneous appeal?
No,
This is
no.
last occasion they have also. This is my instruction that last occasion they have entered appearance in the
How are they
in the proceeding, my lord.
In the miscellaneous appeal?
Yes, yes.
Lordship, my instruction I have not added as a party respondent. Also, file the appeal without adding as a respondent.
Have you filed an application for being
To that
added?
extent, I have no instruction.
He's saying so.
No, no,
If
no.
that is so, I can direct the miscellaneous appeal to be disposed of.
Yes. To that extent, I have instruction. No application was filed by my client.
Please take instructions, otherwise your appeal is infructuous. Please show it to him that he has been impleaded. He is a party.
2025. This is my instruction. My they have also the application order.
Please show it to him so that he can take instructions. I'm making it only not today. Yes, please take instructions. Not today, Korodin. Yes, next. Please
No,
take
Lordship, that application was filed by the appellant. That application was filed by the appellant.
Yes, I have filed whatever rule 10 application, adding them in the.
No, appellant means her client.
Yes.
Yes.
So,
That
that my client was not added.
Application has been filed, my lord.
It has not yet been added.
No. Lordship, kindly see.
Application filed, my lord.
Application filed.
Since they have
The
added,
application has been filed.
application has been filed, my lord. Application has been filed.
Yes.
Order was not passed, my lord. This is my instruction. Since
The
lordship.
date fixed in the appeal.
13th is the date fixed. 13th of the next month is the fixed, my lord.
13th of May.
May.
Have you served a copy of this application upon them?
No.
Yes, my lord. I have
Till
served.
date, no, my client not.
No, not this application. Order 1, Rule 10. Order 1, Rule 10.
That I have to take instruction, my lord. That
No application was
Have a copy of the application.
yes, my lord. I have the copy, but I do not know whether that.
Please take instructions I am keeping tomorrow. Give a copy to your learned friend. Order 1, Rule 10. Yes, not today. Next.
In course of day, my lord, I have served.
Yes. Yes, please take instructions whether what is the next date fixed?
13. Date
Yes.
fixed was 13. Lordship.
11.
Yes, who is
Wait,
the
please, wait, please.
Yes.
This is a petition, prefer this distribution application for expeditious disposal, my lord, of the, my
Of
lord,
what?
ejectment suit, my lord. That has been filed in, my lord, in the year 2022. Thereafter, 7172 application has been filed. 711 has been filed. That has not been yet been disposed of, my lord. My lord, next date is, my lord, fixed on 22nd of May.
You are the plaintiff.
I am the plaintiff, my lord.
This application under Article 227
my lord, this is also identical suit, my lord. This is also eviction suit, my lord, where my lord 7172 is pending, my lord, from last year.
Only 7.1 and 7.2.
7.2, my lord.
This application under Article 227 of
I'm appearing on behalf of the petitioner, my lord. I'm praying for a week's accommodation, my lord. There is a caveat, my lord. We cannot serve it upon them. But kindly grants me liberty to serve and come back. My lord.
Yes. What is there in your Order 7 Rule 11?
Mr. Bodhan has been engaged in this matter, my lord. He is out of station, my lord.
Say so. You have said caveator has not been served.
No,
Please move.
that is
Let
also
me
there.
see whether there is necessity to serve upon the caveator.
Mr. Bodhan is engaged in this matter.
That you did not say at the beginning.
Kindly grants me.
An accommodation has been.
I am appearing with the plaintiff petitioner.
Yes.
Yeah, nature of the impugned order, amendment application was rejected. On the ground, trial has been commenced. Lordship, fact is that suit filed for declaration, title, and permanent injunction. During pendency of the suit,
trial has commenced.
Only date fixed for next date fixed for PAH.
Is it so? Where is
yes.
that?
Only next date for fixed for whole order sheet আছে দেখো for PH no trial has been commenced, and on the next date written statement amendment of the written statement was allowed. The subsequent event.
No, who are you?
I am the plaintiff.
Yes. So what is the order you are challenging?
Lordship, I challenge the order.
Dated 24th of July.
Lordship.
Oh, I was thinking
24th of July.
So 24th of July and 31st of August, amendment of written statement was allowed.
Lordship.
So you are challenging both these orders?
No, that order I am not challenging.
You are not challenging.
No. Lordship, earlier order was challenged during pendency of the suit. Defendant trespasses the plaintiff's property by and constructing the temporary structure. I make an amendment to subsequent event, praying for mandatory injunction for recovery position. If without amendment, suit was failed. I am bringing the whole order sheet, only date fixed for PH, but handwritten copy so that I cannot annex, Lordship.
What is the nature of the amendment which you are seeking?
Lordship, during pendency of the suit, the defendant trespasses the suit property by constructing temporary structure.
Where is that?
Lordship,
Show me the amendment application.
my amendment application, Lordship. Page 31, Lordship.
31.
Lordship. তফসিল সংশোধন page 32, Lordship. Page 34, Lordship. থার্ড লাইন গত ইংরেজি 21/6/2022 তারিখে সকাল 8টার সময় বেআইনিভাবে জোরপূর্বক নালিশি ক1 তফসিল সম্পত্তি 80
This application was filed.
24, Lordship.
Why so much of delay? 2 years. What prevented you from filing this application prior to this?
Lordship, that is true, Lordship.
So,
But actually, Lordship,
this application
Plaintiff, my lord. My lord.
Bhattacharyji is
Copies are-
appearing. Minal Kanti goes, yes, what do you want?
For short password, my lord. It's on-
Short passover.
It's on the way to this Cornwall Road.
The impugned order is against my evidence was closed, my lord. There's a caveat. Copies were served upon the other side, my lord.
You have soft copy?
Yes, my lord.
Yes, ma'am.
Copies were served. I tender apology for not having the affidavit of service, but this is the receiving copy, my lord.
That is not disputing.
The dispute is with regard to.
Yes, Mr. Sarkar, the evidence has been closed. Adjournment prayer was rejected.
Change brief, my lord.
My lord, kindly, my lord, being short password, it's on the way to this program. Short password.
115. Yes. একটা 10
কপিটা থাকবে দাদা?
একটা 10. Yes, call the next matter.
My lord, the copy.
এটা দিয়ে দিন. Yes, next.
But for the caricatures, no copy has been served
Well,
upon.
which item?
I do not 16, madam.
Madam, let it be called on first. Yes.
16.
I
I'm for the petitioner, my
my
lord.
lord, I am the
I'm very sorry, my lord.
no copy has been served.
Why have you not served?
I was
Mr.
not here, my lord. I'll go to.
Kindly a copy be served upon me and then.
Yes, Mr. Banerjee, what is this matter?
My lord, my application under section 5 of the Limitation Act, along with my 7.
Yes. It's not maintainable, Mr. Banerjee.
Your lordship knows, my lord. Your lordship kindly consider my inadvertently, my lord. That are not. My lord, your lordship kindly consider, my lord.
Is there any power, section 5, to condone? Supreme Court judgment.
I know, my lord, your lordship.
Then if you know this
your lordship kindly
application,
consider it, my lord. Otherwise,
consider.
Otherwise, give me time.
Yes.
Expeditious disposal of the suit for eviction of trespasser. On as early as on 2023, date for argument has been fixed. Defendant has filed frivolous application. Ultimately on 8
It has been fixed for argument on 9th of June 2025.
27th and 27th March and 28th March date has been fixed for my argument. And thereafter, yes.
Yes.
And thereafter,
your argument has been closed.
Only 5 and 7 minutes has been given to me.
Only
5 and 7 minutes on that date has been given to me.
how many minutes you want? Or hours?
Only 1 hour, 1 day.
This application under Article 227 of the Constitution of India is at the instance of the
argument has been fixed, my lord.
Please don't put undue pressure upon the judicial officers. Yes, it's fixed for argument. Even then you have come. There's a fit case for dismissal. I have not dismissed.
From 2 years, the argument is going.
All right.
For 2 years.
Yes, yes. Yes, what is the next matter?
Lordship, I am for the petitioner. The tenant is the petitioner before your lordship. I have challenged 2 order, lordship. By the first order, lordship, my application, lordship, for directing the advocate commissioner to lordship supply all the evidences that was kept on record. And by the second order, lordship, my 7-2 was rejected and defense was struck off.
7-2 rejected. Why?
The learned trial judge was of the opinion that I have not paid the area rents and I have not also
admitted areas.
Yes, and I have also not disputed the landlord-tenant relationship also. But lordship kindly takes up
The
my
fact that you have not deposited the admitted rent.
Yes, but I have lordship disputed the landlord-tenant relationship. Lordship kindly comes to page 35. This is my 7-2 application. Lordship page 37. 4D.
What is the dispute you have raised?
Lordship,
is the
we say,
dispute?
yes, we say that Lordship, we were tenants under one Komola, Kalipodo and Dulal, Lordship.
Yes.
And Lordship, we don't have any Lordship landlord-tenant relationship with the present Lordship plaintiffs.
Who are the present plaintiffs? Who are they? How they are related with Komola?
Some of them are saying that they are the heirs of Komola, but Lordship kindly sees. But regarding the rest, nothing, Lordship. Lordship kindly sees my paragraph 4D at page 37, that the defendant states that there was and is no relation between the parties to the suit as landlord and tenant. As has already been stated that earlier one Komala Rani Shaha, Sri Kalipodo Shaha and Sri Dulal Chandra Shaha being owners of such and such, inducted the defendant as tenant for the purpose of conducting his business of bedding materials. And Lordship will also kindly see the prayer portion, Lordship, at page 38. The first prayer, your honor may be pleased to determine the dispute as to the relationship between plaintiff and defendants as landlord and tenant, and may further be pleased to determine whether the defendant is a defaulter.
Are you depositing 7-1?
Yes.
How?
Lordship kindly sees there was an
If
application.
there is a dispute, how could you comply with 7-1?
No, I was from that day. Lordship kindly sees page 34. My prayer was to please page 34, Lordship.
Yes.
That the defendant begs to deposit the month rent only before civil deposit, before this honors court. From the current, Lordship. We are depositing the current.
Yes, so current, if there is a dispute, you have accepted that.
No, but Lordship, regarding that relationship, and Lordship, moreover, in my 7-2 application, Lordship, evidence was going on.
If there is a dispute,
yes.
if there is a dispute, then you have to file 7-2.
Yes.
7-1 is a no dispute situation. So if you have complied with 7-1.
Yes.
Have accepted rent to be the landlord.
No, I am lordship depositing the current rent. But regarding the areas,
Whatever it might be, current you have accepted, you could not have deposited if there is a dispute.
but
Why you will
lordship,
deposit current?
but lordship, if there is a
Depositing current, to whom he will deposit or for to whom? It says landlord.
but lordship
So,
pending lordship adjudication in 7-2.
You need not deposit anything under 7-1. You need not deposit anything after 7-1. Take that risk in 7-2.
But lordship, that has to be dispute. That dispute has to be adjudicated. Lordship.
Yes, then you need not comply with 7-1. Since you have complied with 7-1, have you not accepted the landlord-tenant relationship?
Not necessarily,
Because
lordship.
kindly come to 7-1. Yes, take the book. Boita Dino. Please read it loudly.
Lordship, on a suit being instituted by the landlord for eviction on any of the grounds referred to in section 6, the tenant shall, subject to the provision of section 2,
Yes,
7-2,
yes.
pay to the landlord the or
For
deposit
whom? Tenant shall pay to the landlord. So this is,
subject to lordship 7-2.
yes, subject
So
to
my 7-2 was pending.
yes.
Pending that lordship, I was going on depositing the current.
Have you brought the judgment of Devashish Pal?
No. Lordship, I have that citation 79 to CLJ, Lordship, which says
The old act, old act.
maybe
Devashish,
Lordship.
Pal has negated all those.
But Lordship, where
So
there
the
is
new act
where
says
there is
you are obliged to deposit.
true, but where there is a dispute of landlord-tenant relationship, Lordship,
Kindly,
it means that.
kindly read Devashish
Here
Pal.
also, Lordship, it is stated that subject to the provisions of 7-2, Lordship.
Yes.
So my 7-2
7-1, Mr.
Yes.
Poti, is a no dispute situation. If there is any dispute, we did not comply with 7-1. It's a no dispute situation. So once you are accepting or you are complying with 7-1, presupposes that you have accepted that. But that also says landlord and the tenant.
True. But Lordship kindly sees my application.
Because there is a distinction subject to is. 7-2 says admitted. 7-1 does not say admitted. So entire thing. So there is no dispute. Landlord says this is the rent, this is the rate, this is the period. You accept, pay, you have to pay that amount and you have to continue. Once you raise a dispute, you have to file 7-2. 7-1 is not necessary. Because you are disputing that. And there, if you admit, you will have to pay. If you do not admit, you need not pay. You need not deposit. But whether you can take that point, I will not.
Even Lordship, no. In 7-1, Lordship, I have disputed that. It is not that I have there also.
You have disputed. 7-1 does not lie.
But that
7-1 is a no dispute.
7-1, Lordship, we deposit at our own risk, Lordship. But subject to Lordship,
So
adjudication in 7-2. But where is the
I
Lordship?
have stated that I am depositing at my own risk. That's the order. Show me that in the application you have said that I am depositing at my own risk. 7-1 you have not said so.
No.
Then
But Lordship, in my written
7-1 does not require also filing a
But Lordship, my defense has been struck off, Lordship, everything goes. Today, Lordship, my landlord-tenant relationship has not been adjudicated. Lordship, kindly seize the order. The learned trial judge has come to a
Has this point not been decided that when the relationship is in dispute, whether admitted rent is to be deposited or not?
Lordship, I need not pay admitted rent, Lordship.
Has this issue been decided anywhere? In a case where you raise a dispute with regard to the landlord and tenant relationship,
Before adjudication under 7-2, I need not pay the area amount, Lordship.
have you got any decision in your support under
That
the...
is 79.
No. In the new act. Don't go to 79. Those are line of
But
those line of
still, then Lordship, I have to see. I have to Lordship see that whether this judgment is still they followed in a current judgment that this has
under
been
the
referred to.
new act, you may have some problem. Please see Devashish Pal's judgment.
That Lordship, I shall see. Devashish. But Lordship, the learned trial judge has come to a conclusion that I have not raised any dispute regarding landlord-tenant. Lordship kindly takes up order dated 5th of February 2025.
I think this is a correct finding.
Lordship kindly sees thus the apparent admission of the
Yes,
party.
yes, you have paid. That is why I'm saying if there is a dispute, you did not comply with 7.1. Once you have
It is
approached
also-
from the section 7.1, it shows that you have accepted.
It is also apparent that there is no
Please
dispute.
consider Devashish Pal. I'm making it not today. Yes. And please also see whether those old line of decisions, when the relationship is challenged,
Lordship, it's
whether
followed.
this language it has been interpreted. If that is so, then this section 5, other things all will go. Because in each and every application under section 7.2, you will be find first line is I'm disputing the landlord-tenant relationship. So in none of the cases, you will have to deposit those. And I think, Akshay, yes. I think there it has been said nearing the last portion of those. Oh, it was considered in this.
And that what I am finding, my lord, I have to go through it. In 2024, probably it has been reversed.
What has been held?
That 2024 judgment, my lord, we have to go through it.
Court proceeds on the basis it's a settled proposition of law that the court deciding the application has sufficient power to extend the time for depositing arrears of rent upon sufficient cause. This is the it proceeds on that is the settled law.
আমার against
Yes, call the next matter.
98.
Yes, expeditious hearing of what?
One application pending, my lord.
What is the nature of the application?
Order C amendment application, my lord, filed by the opposite party plaintiff, my lord. 2014, my lord.
You are the defendant. You want expeditious? It's not a suit for eviction, I think.
Partition.
Partition suit, yes. Partition suit, the defendant will be interested. Why are you expediting the suit? You are enjoying the larger chunk of the property, more than your share. Even then you want.
2014, my lord. Application filed in 2014.
What happened on 6th of September 2024?
6th of September, my lord. Application.
Show cause was directed to be submitted by the plaintiff as to why the suit should not be dismissed for default. What happened on that date?
Show cause filed, my lord. The show cause filed, my lord.
Accepted, not accepted? Accepted. Show cause
Pending.
pending, not accepted. You are accepting the show cause, so the let the suit proceed. I can direct from here and I can expedite the suit.
Expeditious, my lord, can accept.
Because you are not objecting to the show cause, so I'm accepting that from here.
Yes.
You have instructions, Mr. Sarkar. This application under Article 227 of the Constitution of India is at the instance of the
As well. Mr. Somlo Bhattacharya appearing on behalf.
Yes, you are here. Move.
I am not on record.
Lordship, on item 20, Lordship, though I am not filed any caveat, Lordship, I am appearing for the defendant.
You move the matter. Since I'm not inclined to take up this matter on personal ground, this matter. No, 21, 22, 23.
No,
20, 21, 22. Yes, 23, yes.
23. But I am for the petition. Lord, the previously, after prior to 2013 amendment of Wakf Act, Lord, the under section 54 of the said act.
Don't move these matters now. Several agitations.
It's Lord, prior to this Lord, new. So Lord, there is no quarrel. That's I checked up Lord in the new act. If here Lord, the proceeding initiated in 2018. Lord, prior to 2013 amendment, the CEO, Chief Executive Officer, was empowered. Initially, encroachment, removal of encroachment.
Yes.
Initially, Lord, the power was that if upon notice or upon inspection he found there was an encroachment over the prima facie, encroachment over a Wakf property, he shall make
a reference to the tribunal.
No, now it is make a reference. So, Lord, this is Lord, the scenario. Here, Lord, if your Lordship takes up once, Lord, the initial show cause notice, or rather prior to that, may I take your Lordship to the, it's an Wakf is at, Lord, the enrolled Wakf, page 23 of my Lord's brief. Lord, it's premises number 7, Chandranath Shimlai Lane. Page 23, once your Lordship takes up. Page 23, Lord.
So an order of eviction has been passed.
Not the order of eviction passed apropos to the decision of the Lord CEO. Lord, what happened?
But Mr. Mukherjee, please come to the ordering part at page 10 of the impugned order. It says the CEO/applicant is entitled to an order of eviction. What is the meaning of this?
Can't be. Lord, I shall. That's why, Lord, I opened my mouth, Lord, saying that the order of eviction has to be passed by the tribunal. It is after amendment, section 54 suggests that he has to file an application on that finding.
He has to make the preliminary inquiries, then make a reference to the tribunal.
Preliminary inquiry has also not been done. I shall show before your Lordship. Lord, it's like our eviction, Lord, our encroachment suit is being filed by the plaintiff, relying upon an Lord, inspection report which has been done by his own. After the suit is being filed, the court is saying,
yes, page
23, Lord, if your Lordship takes up once. I will take your Lordship what is the Wakf property. It's consisted within premises number 7. Lord, the name of collector and Touji number and name of Thana. Lord, your Lordship will get Lord, the 7 Chandranath Shimlai Lane. We are in the middle of that.
Where is
Lord, it's column number
7 Chandra.
Yes.
Not Shimlai Lane.
And the how much property at the bottom your Lordship will get, Lord, it's 3 katha of
area of land is 9 kathas of
9 kathas. Yes, it has been segregated in 3 parts, but area of land is 9 katha.
Yes.
Now, if your Lordship takes up, Lord, my show cause notice is at page 35 of my Lord's brief.
Yes.
Lord, whereas it has been reported, has your Lordship got me?
Yes.
Reported that Janab such and such secretary in respect of such and such Wakf estate that you have forcefully and willfully trespassed and taken possession of the Wakf property as mentioned in the schedule below. Accordingly,
yes, what happened after this?
Now, my Lord, I have been directed to serve, my Lord, to give my reply to the show cause within 10th of September. If your Lordship takes up, my Lord, my reply.
Yes, what happened after that?
Page 104. My Lord, I have stated.
What is page 37? Page 37 is the reply to the show cause.
Lord, page 37. Bosh. Page 37, if your Lordship takes up, Lord, turns over the page to page 38, I have stated that my premises is 13, which was originally owned by Santosh, Ashutosh, Pronotosh and Bhavotosh. Paragraph 2, your Lordship.
Yes.
Thereafter, Lord, 2 of Santosh and Ashutosh, Lord, it transferred to Khetro Mohon. Paragraph 3, by dint of a registered deed. Has your Lordship got it?
Yes.
Paragraph 4, rest 2 Milord owners, Pronotosh and Bhavotosh also transferred to Shukhendu Mohan Roy, who is the son of Khetro Mohon. So, my lord, Shukhendu and Khetramohan becomes, my lord, the owner. They both of them transferred to my mother. My mother, my lord, that is at page, my lord, paragraph 6, latter portion at page 39. My mother's name is Eva Koch.
Yes.
And upon the permission of my mother, I have set up, my lord, the industry at, my lord, premises number 13. This is, my lord, specific case of mine. I have, my lord, annex, my lord, page 41, the deed.
Yes.
Your lordship will get, my lord, the Khetramohan and Shukhendu is transferring to my mother. My lord, your lordship will get the schedule.
Yes.
My lord, at page 47 of my lord's brief. It's 13.
Yes.
Now, my lord has seen, my lord, the show cause. Show cause is dated. Show cause Lord, show cause is page 35. It's dated.
That was the earlier show cause.
I shall come, Lord.
Again, another show cause.
Lord, that's right. 8th of August 2018 is the date of show cause.
Yes.
I have been directed to give, my lord, reply by 10th of September 2018. I have given. Lord,
Yes.
now inspection report. May I take your lordship? There are two inspection reports. First inspection report is at page 101 of my lord's brief. I shall compare it to the show cause, my lord. This 101 was happened to be done on 18th of April 2018.
What is 101?
101 is, my lord, the inspection report.
Yes.
It's, my lord, if your lordship turns over to page 102, it's dated 18th of April 2018.
Yes.
So it's prior to show cause. There is no evidence that I have been, my lord. The law also does not want that this, my lord, prima facie inspection has to be done with prior notice. But I admit this has been done, wherein they have found I have encroached 2 kathas at 7.
Where is that finding?
My lord, if your lordship takes up page 101, my lord, third paragraph, last
marked portion. Thank you for marking.
My lord.
That marked portion. Thank you. It becomes easier.
It's my mistake.
You are the advocate on record, Mr. Mukherjee.
But still, my lord, this I have missed it.
It helps at times.
That's
yes. Next,
let these 2 kathas, my lord, this is, my lord, prior to the show cause. Law, my lord, I shall suggest before your lordship, after this, my lord, show cause, they will have to done a preliminary inquiry. The case is of encroachment, my lord. Kindly takes up the next, my lord, inspection report.
So this was the first inspection report.
This was first inspection report prior to, my lord, show cause. Lord, page 123, if your lordship wants, takes up.
Yes.
This is, my lord, the inspection alleged to have been done on 2nd of August 2021.
Yes.
Has your lordship got it? My lord, pursuant to such and such, my lord, kindly takes up, my lord, the third paragraph. Also had been to 13 such and such to contact Kia Shet, but he refused, my lord, it ought to have been she, refused to come down and to see the undersigned. My lord, no prior notice. It is a case made out in their inspection report that he has gone to 13, where I am there, and I refuses to come down. It is worth to mention here that the undersigned had inquired 54 of the Wakf Act 1995 about the Wakf estate dated such and such against Kalachad Mondol and 13 others, which included Kiashet, the present building, and report submitted on, this is the previous report, for starting a proceeding under 54 of the Wakf Act against the encroacher mentioned above, which is still pending. Now, to stop the ongoing unauthorized construction at 7, such and such, we may write to the DG building, Thika controller, and OC Chikpur PS in this effect. So this is being done without giving any notice to us.
Yes.
Now, what is the Shigio's observation, Lord? Thereafter, Lord, I have given a. Lord, if your lordship takes up paragraph, page 128, it starts after giving me hearing. It is 54.3.
Yes.
Paragraph 9 at page 130. It's relevant because others have not turned into other 36 encroachers, alleged encroachers.
Paragraph 9.
Paragraph 9 it appears, Lord, has your lordship. Yes, it further appears.
I hold that it has been sufficiently proved that the objectors fully described in the schedule are being encroachers in the Wakf property.
Milord, if this is, Milord, it is their own, Milord, surveyor who is conducting an inquiry without my presence. My specific case is that I have constructed my establishment of factory in my own property within the permission of my mother, which is the Rayati land, no way connected with the Wakaf estate. Wakaf is at 7. My construction is at 13. This encroachment, they have simply relied upon that, the report, and passed this order referring to the tribunal.
Which report?
Report, if your lordship takes up, this, they have not mentioned about the date of the report.
Wakaf property 7.
7. I have shown before your lordship page 23.
Yes. Yes.
Now, this is reference. They have filed an application before the Wakaf tribunal. That is at page 78. I will not trouble your lordship. That is with regard to passing of the eviction order. My written statement, very important. I have taken this point. Page 134, it starts. My written statement before the tribunal, because the tribunal has to pass a demolition order and has to inquire whether the inquiry envisaged under section 54.
Now, what happened before the tribunal?
The tribunal simpliciter not have passed an order of eviction, rather not passed an order of eviction, stated that whatever the observation of the CEO is correct. But kindly see once paragraph P and paragraph Q at page 143. My specific case is that you have never served me any notice. This inquiry is being done behind my back, and there is no inquiry that has envisaged under section 54(3 prior to giving a reference to the tribunal is being conducted by the CEO. Paragraph P and Q at page 143, my written statement.
In the impugned order, there are as many as 37 encroachers.
Yes,
you are whom?
I'm only Kiashet. I'm 37, last one, because others 36 has not contested.
36 has not contested
at any stage. It's the observation of the tribunal starts at internal page 7 of the order, impugned before your lordship. Page 7, last paragraph, may I read?
Yes.
After inquiry, Mihir Kumar, such and Kiashet were also afforded opportunity, and after giving them an opportunity being heard, the CEO passed an order whereby all the encroachers along with Kiashet were found to be in illegal occupation of the Wakaf property. It is also found that Kiashet running commercial factory in the premises number 7 Chandranath Shimlai Lane, which is a Wakaf property. In other words, order passed by the applicant on such and such.
According to you, 7 is not a Wakaf property.
According to me, I am at 13. My construction is at 13. 7 is a Wakaf property I am not touching. There is a case of encroachment.
Yes.
Made by them. So it has to be decided, my lord, in presence of both the parties. Where is that inquiry? That has never been done. That is my case. The tribunal.
You have a copy of the act?
Yes, my lord, may I? Now. The provision is being quoted in the order impugned, page 8. নতুন একটাই তো দেখা। Oh, sorry, my lord, your lordship takes up this. This is my lord.
That is why I asked you.
Not page 50, sorry, not section 54. It's at 3 link. First is, my lord, subsection 1. Whenever the chief.
Give me a minute.
Sorry.
So according to you, 55(4) has not been complied with.
Not only that, my lord, 54(3) has not been complied with. Because prior to referring to the tribunal, kindly see, if after subsection 3, if after considering the objection received during the period specified in the notice which I have given, and after conducting an inquiry in such manner as may be prescribed, I say, my lord, this has not been done.
But Mr. Mukherjee, have you challenged the order of this chief executive officer?
Yes, I have.
Where?
Before the tribunal.
Yes. So what happened to that?
That was turned down simultaneously. A civil revisional application is pending before your lordship's court.
So what happened to that? If there is no stay,
no, my lord,
where is that civil revision application? Because Mr. Mukherjee, unless you succeed in that, there is nothing. You cannot take the point of 54(3) now.
Today, my lord.
Where is that civil revision application?
3249 of 2022. Oh, that your lordship.
I'm releasing this. Get it assigned
kindly,
before
kindly
that.
consider I have a second link of submission. Even forget about Lord, my Lord challenge of CEO's order.
Mukherjee, these two are to be heard together.
Lord, I say I have an independent legs to stand, Lord, in 54(4). The tribunal has to consider whether this 54(3) has been complied. That is, Lord, the scope of inquiry before the tribunal.
Mr. Mukherjee, that is one. But according to you, you have challenged that specifically in another civil revision application.
Lord, I have challenged regarding Lord here. Lord, it's a Wakf Lord application which has been allowed by the tribunal. The tribunal has to scrutinize two things. First, whether an show cause is being given upon a prima facie satisfaction. After the show cause, whether a preliminary inquiry has been done, and the conclusion of reference whether is correct or not, and thereafter the tribunal has an independent authority to revisit the issue. Neither thing has been done. It is the tribunal who has stated as if he is reiterating whatever his CEO's
how this inquiry is to be conducted? What does the rule prescribe for that?
Inquiry, kindly consider it's an encroachment. It's an issue with regard to the encroachment.
Yes.
That's why the inquiry has to be with regard to the inspection. Otherwise,
how that inquiry is, this encroachment is to be decided? Who will make that inquiry?
That inquiry has to be done by
the officer?
CEO. It's the section provides
the CEO competent to decide the issue with regard to encroachment. He's that qualified person.
That's why the opening language of section 54 is that whenever the chief executive officer considers.
Mr. Mukherjee, kindly come to section 3, subsection P.
The chief executive officer is satisfied that the property in question.
No, 3P. Definition clause. I think there is a provision for appointment of a survey commissioner because it's a case of encroachment. How can the CEO decide that?
That's why, my lord, it has been done by OSD.
CV survey is section 4. Section 4, subsection 4 says survey commissioner, while making an inquiry, summoning witnesses, requiring discovery, requisition, these are the things, local inspection or local investigation. So CEO is not the competent person.
Yeah, in the present case, CEO has not done. It's the
you said CEO has done.
CEO has passed the order, my lord. The inquiry, my lord, both of the inquiry report which I have shown before your lordship, that was being done by the lord officer in special duty. OSD. That I will have to inquire, my lord. I am not on that. But this preliminary inquiry has to be done, my lord, in adherence to the law. It's a case of encroachment made by them. No prior notice. My case is that no prior notice, nothing is being done in my presence.
Show me the order of the chief executive officer with regard to this encroachment. Finding on encroachment.
Yes. Legible copy. Look, page 128, it starts.
Yes. Where is the ultimate finding with how it has been?
Yes, Lord, I take your lordship. Lord, I have shown before your lordship the finding is paragraph 9. May I read with you?
Finding is paragraph 9, but what is the basis of this finding? How it has been dealt with? Because it's a case of encroachment, Mr. Mukherjee.
Lord, may I take paragraph 3? From the inquiry report.
Yes.
From the inquiry report, it appears that although the alleged encroachers have occupying the Wakf property, but they failed to produce any document in support of their claim of occupation in the Wakf estate. At the time of holding inquiry, he found that the encroachers, namely Mittal Mondol, serial number 9, is in possession of 6 rooms measuring about such and such, such and such, such and such, is in possession of the room. Ananto Haldar is in possession of such and such. Milord, these are the other person. Milord, I am not disturbing. Last portion, as such, Milord, of that paragraph. As such, the inquiry officer suggested to start proceeding under section 54 of
Where is
Act.
the report of the inquiry officer?
Milord, yes.
How it was decided that it's the other way around. It says that they are in possession of this. They failed to produce any document with regard to that.
Is prior to issuance of show cause.
Show me the how this inquiry was made.
No. First, Milord,
Because what is troubling me is with regard, this is a case of encroachment.
Yes.
So how this case of encroachment was decided?
Milord, the first inquiry report, page 101. This is 18th of April 2018.
This does not say anything. How it was decided?
It is something, Milord.
101. It says during the spot inquiry, physically only such and such, such and such, such and such rooms were found in possession of 5 katas issued by such and such possessing, running a commercial factory in and around in premises number 7. So if it is a question of encroachment, how this was decided that this construction falls within 7?
This is, I'm Milord, just giving your lordship an example. I am the plaintiff. I filed a suit saying that there is an encroachment made by the defendant. Defendant denies. A removal of encroachment order passed by the learned trial judge, relying upon an independent Milord survey report annexed to the plaint.
Yes, you serve a copy.
Milord, kindly, Milord, I have Milord given Milord, they are going to Milord affect this Milord by evicting me. Milord, this is Milord the supplementary affidavit. I shall serve this also. Concerned police station, Milord, ask me.
By the order impugned,
My lord, may I only serve to 1 and 2 because other 37 encroachers, my lord, 36.
1 and 2.
24.
Yes, Mr. Rai.
I'm for the petitioner.
Yes.
Lord, the title appeal of 2003. But I'm for the respondent. Lord, if your lordship, Lord, expeditious disposal, Lord, of the title appeal within a time-bound period.
What is the nature of the decree?
Lord, 36-37A of the Moneylenders Act, my Lord, suit was filed initially. That was in 1992.
What is the stage of the appeal?
Stage of the appeal, my Lord, my Lord, came the appellant.
This application under Article 227 of the Constitution of India is at the Yes. Yes.
My lord, here, the suit was filed by the plaintiff, by the petitioners, claiming title to the property. It's a suit for declaration and injunction. Now, during the pendency of that application, the suit.
What was the suit filed?
Suit for declaration and injunction.
What is the declaration sought for?
My title. My father died, pursuant to which mother and
you have
daughter.
filed a suit for declaration, title and permitting. Yes. And what is the other suit?
The other suit is a probate proceedings filed by the defendant, who is my uncle. Now, during the pendency of the suit, an application was taken out by the defendant seeking stay of the suit, though no nomenclature was there, neither under Section 151 nor under Section 10 of CPC. An application was moved by the defendant in my suit, and the suit has been stayed, which has been assailed by me before your lordship. Your lordship comes to the impugned order.
Give me a minute.
My lord.
Yes, the defendant is claiming title by virtue of the will, and you are claiming title by virtue of the inheritance. So, what is the difficulty?
My lord, if the suit
is the probate proceeding, if the probate is granted,
but let not the suit be stayed. Let it continue, and the decision will not be given by the court, by the suit court.
Where is the judgment of the Supreme Court?
I am not equipped, but there is that simultaneous proceedings can continue. And since
show me the judgment.
My lord, kindly takes up the matter tomorrow. I had the judgment. I came from the hospital. My dad is there after a surgery. So without those books, I have come to the court. There are 3-4 judgments on this particular issue, my lord.
In 2004, in same volume, there are 2 judgments.
My lord. Let the matter be taken up.
One is in your favor, other is against you.
Against me. The conflicting judgment is there.
All right.
Day after tomorrow, your lord.
On the prayer of the learned advocate for the petitioner, is this matter? Wednesday.
26, my lord, I'm for the plaintiff petition. It is an expeditial disposal of title suit of 2012, my lord. It's actually an application for mean profit is pending, my lord. Suit has been decreed. Eviction has been done, my lord. Plaintiff got possession of the suit property in 2018.
Now you want mean profit also. You are not happy with the possession.
No, they have run the business for 8 years long, my lord. From 2010 to 2018,
That is
the
why I'm
run the
saying that you
business.
are not happy with the eviction.
The report of the valuation commissioner has been submitted.
Against the bank.
Bank, my lord, UCO Bank. The report of the valuation commissioner has been submitted. Valuation commissioner deposed as PW2. The report was exhibited documents, my lord, but in spite of that, suit is not ending, my lord.
What happened on 21st of May is the next date.
Next date, my lord.
This application under Article 227 of the Constitution of India is at the instance of the
Yes, ma'am. In this matter, I am for the petitioner.
Yes.
His application for expeditious early hearing, the application order 1 rule 10.
Yes.
Rule 10(2). This application filed on 29th March 2020 before.
None of the matters will be disposed of. All matters are expeditious. All suits are directed to be
That application
decided
is-
expeditiously. None of them will be decided expeditiously.
That application is pending since 29th March 2022. Copy all served.
None of the applications, none of the suits will be decided expeditiously. All of you, further hearing, part hard, arguments, all those. I think I have to think of passing different type of orders. This application under Article 227 of the Constitution of India is at
The classic example.
So,
Your Lordship heard this matter.
hotly contested matter.
Yes, yes.
Hotly contested.
Your Lordship heard this matter on the last occasion, remanded it back, asking the trial court to extend the interim order and to consider whether on what conditions, my lord, the interim order can be extended. And once your Lordship did that, I knew what the fate was, and that's exactly what has happened. Now, what happens is, my lord, they file once your Lordship remands it, they file an application.
How much time it will take?
I'll take a little bit of time, 10 to 15 to half an hour.
দুটোর সময় কি আছে? দুটোর সময় অন্য কেউ? Tomorrow? কিছু করতে হবে না, এমনি রাখো। Yes, call the Passover matter.
Oh, tomorrow, my lord, in a state of tomorrow, my lord, can it be
They
after
will,
tomorrow?
the execution, my lord, is stayed on the condition that I will have to pay my lord 4.67 lakhs in one matter and other matter.
Large
another
chunk
5
of
lakhs.
property, Mr. Chatterjee, you are
No
in.
land, there was no adjudication. No adjudication. Nothing whatsoever. They give evidence. I'm not even allowed to look into the evidence.
Yes.
No, on the next day, finished.
It's not an exorbitant amount so far your
It's an
client is concerned.
extremely exorbitant amount. I will show how Supreme Court has watered down Miller Atmaram. I'll show your Lordship that.
2008.
No, 22. Has watered it down to a very large extent. It can't be like a windfall for them. They are not even the owners of the property. That is, my lord, my submission, my lord, in the entire thing. That they have lost rights under the Extended Acquisition Act. That is what I have, my lord, the matter about in the order 21/97.
That is the main matter. Will be
Absolutely, my lord. So now what happens is that it is like a windfall upon them. They don't want the matter to be heard out. Your Lordship, on the last occasion, there was the condition that the matter has to be heard out by this time. They don't want the matter to be heard out. They want money from me. And that's not bona fide.
Yes.
Lord, only one indulgence.
Kindly
In
keep
a
it
state of
tomorrow,
at
my lord,
2 p.m., my lord, it may be in the first half, my lord.
Tomorrow.
Tomorrow first half.
Today, 2 p.m. is, I think, other group of matters.
Yes, tomorrow first half.
মানতে লিস্ট তো ফার্স্ট হাফেই তো জজ সাহেব তো বলছে মোশন তো
কালকে সেকেন্ড হাফে থাকবে না ফার্স্ট হাফে?
ফার্স্ট হাফেই তো স্যার, সেকেন্ড হাফে নয়।
First half, not second.
Yes.
Normally,
Did not feel, yes.
Seven.
So difficult.
7 my lord, I am for the opposite party, my lord. But I prayed before your lordship that the matter can be disposed of, my lord. I am
Where
for
is
the
the
opposite
other
party,
side?
my lord.
Other side
Morning also, Mr. On the ground of Mr. Owen Banerjee, my lord.
Not here. Yes. ওই একটা 10-এর যেটা ছিল,
My lord, kindly take it up tomorrow, my lord. Much.
not today করে দিন, tomorrow করে দিন।
15, for the petitioner plaintiff, my lord. My lord, initially application seeking for certificate of probate was filed by me, and after that,
Yes, Mr. Ghosh, prayer for adjournment rejected, evidence closed.
Kindly come.
What do you want? Cost.
Kindly, prior to that, kindly come to page. The order dated. Page 34.
Yes.
Page 34, kindly come.
Page?
Page 34, order dated 9 July 2024.
Yes.
Evidence of PW started in the year 2020.
No, 2024 fixed 20th of September for evidence on behalf of the plaintiff.
Kindly go through this order dated 9 July 2024.
9 July, yes, I am at 9 July.
9 July 2024, the learned court below recorded that this is a suit of 2018. They did not pray for the evidence of the attesting witness. Rather, they have filed an application for the witness of the scribe. These are all dilatory practice. Now, the date was fixed on 20th/9/2024 for PW. Now, the next date, adjournment was allowed. This is not a case, the only last, the impugned order, they are prayer for adjournment allowed, rejected. Now, and in the by the impugned order, the adjournment.
my lord, may I? My lord, after order number 40, my lord,
In order number 40, my lord, it is correctly mentioned at the bottom that the plaintiff is hereby directed to take necessary steps upon the attesting witnesses. And once ID, the plaintiff's evidence will be closed. My lord, thereafter, my lord, on the next date, my lord, my erstwhile learned advocate who has passed away, prayed for adjournment. It was granted without any further adverse direction for 20 order number.
So that is why you are entitled to pay for adjournment.
No,
If there is
absolutely
no adverse
not, my lord.
direction.
The difficulty is, my lord, absolutely not, my lord. The difficulty is, my lord, I don't know why the erstwhile previous learned advocate did not proceed for the filing of the will. The main difficulty is if my witness, my evidence will be closed, my lord, I will not be able to bring the attesting witnesses, and my will not be my mother's.
You are trying to delay this suit.
Absolutely.
What can be done?
I had, my lord, from the order sheet, my lord, kindly consider that.
Yes,
from,
yes.
Adjournment petition not annexed.
Only-
There is no ground for my learned
It's
maybe saying this is
what happened, my lord, on the in the impugned order, my lord, is a change brief. I received the brief.
Maybe
and
you have accepted the assets, also accept the liability also.
Absolutely, my lord.
If you have accepted.
My lord, kindly consider that. Otherwise, my lord, I will. On the impugned date, my lord, fresh vakalatnama was filed, and I appeared and I prayed for adjournment, my lord, without any unnecessary.
Yes, how much cost?
My lord, without any unnecessary delay, my lord, without.
That will be there, but how much cost?
My lord, kindly
Yes,
consider.
suppose how much cost you want?
My lord, kindly consider.
The early disposal of my and the direct, my lord, the learned court below, my lord, to dispose of this suit, my lord, the time bound manner.
How much cost?
My
That will be done.
My lord,
nod your head in this way. How much cost?
My lord, kindly consider the cost. My lord, cost will be because
suit of 2018.
I understand. In between the time, my lord, 2 years was for the COVID period, my lord. After that, it was a mistake, my lord. That 9th July order.
Don't bring COVID now. COVID.
9 July order is a mistake. There was, I admit that there is no need to bring the witness of the drafting advocate, my lord. I admit that there was no need. Kindly consider about the cost, my lord.
This application under Yes.
41.
Yes.
My application, which has been fixed before my lord. Well, this arises, my lord, out of a my lord award which is being executed before my lord the learned my lord commercial court at Alipur. Now, my lord, we had filed earlier also 227 applications, my lord, which were, my lord, not taken up once, and thereafter, my lord, it is there in the list, which is item number 215 and 216. Now, my lord, thereafter, she had passed an order, my lord, whereby, my lord, the writ has been issued for attachment of my properties as well as my bank account, which, my lord, is my day-to-day account dealing with the, my lord, employees and all. Now, the issue is that, my lord, this is a section 47 application which I had filed before the, my lord, learned commercial court at Alipur, stating that, my lord, the award is not executable because the award is a void award. So therefore, my lord, a section 34 is not maintainable in this issue. Lordship knows, my lord, in an award, generally section 34 is filed for setting aside. But in this case, I cannot file a section 34 application because, my lord, this is an award which is not executable at all. So, my lord, I only have to show that, and now, my lord, luckily, my lord, by this time, two of the honorable courts have also, my lord, in similar situation has held, my lord, division bench judgments, wherein it has been held that in a situation like this, my lord, the award is not executable, it is void, and, my lord, in a case where it is a void award, only section 47 is maintainable. So, my lord, I have to only show that. So, for that, my lord, I have to show a little bit of the dates, my lord, which are very relevant. 1349.
Senior friend, my lord, commences with this application. Now, my lord, this application is filed against one of the interlocutory orders passed in my execution proceeding.
Passed in
my execution proceeding, one of the interlocutory orders. My lord, that interlocutory order was with regard to, my lord, issuance of writ, my lord, upon, my lord, the learned receivers to proceed. Now, my lord, as far as, my lord, the section 47 application is concerned, its dismissal and, my lord, the challenge thereto, that, my lord, is not probably, my lord, subject matter of this civil revision. That is there, my lord, in the two other civil revisions that, my lord, my learned friend is indicating. Now, my lord, if that, my lord, my learned friend is willing to press, my lord, with regard to, my lord, maintainability of the section 47, whether it was dismissed, good, bad, indifferent, my lord, then, my lord, probably this civil revision is not the one that, my lord, my learned friend is pressing.
But if I press this, very well, you make your submission.
I have a list of dates, my lord, that I have, my lord, the arbitration award was passed in 2022.
But that is on, this is on merits. Then, my lord, I have to make my submissions.
Let me submit. Kindly give me 2 minutes. Let me submit. The arbitration award was passed in 2022, my lord. The application, the execution application was filed in 2023. I'm not going into the months. I have the list of dates, my lord. The first application, the order, my lord, the execution application was filed on June 20.
What is according to you, these three applications are to be taken up together?
He's pressing, my lord, the section 40, challenge to section 47. All these three applications has to be taken up together, my lord. It cannot be hard piecemeal, my lord.
So all are there in my lord's list. All are there in my lord's list.
Mr. Ray is, my lord, leading me. Probably when the matter was mentioned, my lord, on Friday, my lord, Mr. Ray was there.
Yes. I have no issues with regard to that. My lord, if somebody has a personal difficulty, lordship will fix it on any day that he is there. I cannot, I will never stand, I never stand. But, my lord, the only thing is that in the guise of this, my lord, they should not execute, my lord, the writ. No. Attachment is, my lord, they can do at any time. That is for
tomorrow.
Yes, tomorrow at 2 p.m.
Wednesday, nay, Judge, can it be on Thursday, my lord?
He was there on that.
Can it be Thursday, my lord?
Thursday, Mr.
My lord, the only thing is that till Thursday, I take his word before my lord that he will not execute it.
Since 2022, it's pending.
No.
Not do anything till Thursday.
Yes.
I'm not passing any orders. List this matter along with give the other two.
Yes, my lord, I have given.
Give
He's saying there is no stay. Then let me press the application, my lord.
Are you willing to execute?
So, so I will give
To that.
so I will give a letter.
I'm not passing any orders. Please don't put the court into embarrassment.
Yes, grateful, man. Grateful.
Yes.
Grateful, man.
Call the next.
You to আছে তাহলে করো তো।
Yes, sir.
I'm sorry. Sorry, man. I got caught, man.
On Thursday, the three matters are being fixed. The other
I think so. Yeah, man. There's one matter cannot be heard separately, man.
Yes.
Absolutely, man. I'm very grateful, man. Very grateful.
My lord, that may be
At 8 p.m. Yes. Call the next matter.
Petition, Lordship. In this matter, I am being led by my lord, senior my lord, Mr. Probal Mukherjee. Well, he is on leg in court number 37. I am praying for a very short passover. देखिए, brief टा देखिए.
My lord, only one prayer for the juniors. They say that, my lord, those two matters may be directed to appear, my lord.
Yes, yes, I've said that. You give the other two CO numbers. I've said that list this along with those two on Thursday.
For their welfare, my lord.
No, I've said that. I've passed an order, but give the numbers of those two CO.
Grateful, grateful.
I passed an order. It's not that. Order will be there. Mr. Banerjee, for you also. It's not only for them.
They don't. Sad case.
Yes.
My lord, I'm for the petitioner, my lord, here. But I have already served upon the caveator, my lord, and they have received. My lord, this is my my lord, I am being led by my lord and senior my lord. Mr.
Pass over next. Yes, call the next matter.
91.
For want of determination.
$92.
None appears for the petitioner at the time. Next. None appears for the petitioner at the time of call.
$94.
Mr. Ravinder Kumar Jaiswal appearing for this for petitioner. He is in leg before court number 16, my lord.
On the prayer of the learned advocate for the petitioner hearing of the matters. Yes, on the next matter.
95.
None appears for the petitioner.
In this matter, this was a divorce proceedings. I am for the husband,
another matter came up from the same proceedings. My lord was pleased to release it, and my lord directed me to remind me when this matter was called on.
I've released the other matter.
My lord, my lord.
Uh, for want of jurisdiction, for
Petitioner, the petitioner before the lordship is the wife lordship filing the instant application to transfer the
for want of determination, let the matter go to police.
Nine.
Lordship,
the opposite party.
Lordship appear for the petitioner, Your Lordship.
But I was not on caveat, my lord, but if a copy can be served on me.
My lord, I'm being led by Mr.
My lord, I am appearing for the petitioner, my lord.
Yes.
I am for the petitioner, my lord. My lord, here, my lord, I am assailing an order, my lord. It is some strange, my lord. I am assailing an order rejecting my defense against an application coordination of delay. Order, my lord, your lordship will find that it is completely without any reason whatsoever. So, my lord, I have come up against that. If your lordship permits them to appear, my lord, I will leave it to your lordship, my lord.
Sir, as section 5 has been allowed, why do you want an ex parte?
Yes, my lord, on the point, no, my lord, not only that, my lord, may I just point out, your lordships have been very cautious in granting section 5 application. Obviously, liberally it is allowed. But my lord, here it was a case of my lord, false statements being made. Complete false statements stood in the way that if there are false statements made, it will not pass any order.
Sir, are you very serious in this?
They have not filed objection for
False statements, my lord.
False statement.
Kindly keeps it on Thursday, then, my lord, may I
They
just
have not filed an objection
Sorry, my
to
lord.
4 extensions. After 4 extensions, so it was and they were allowed to argue. It was not that ex parte. Ex parte was not there. Written objection, 4 extensions. They could not file the
4 extensions for what?
For filing their written objection before the learned trial court. They did not, for which.
All right, so you have not been served.
I have not been served, man.
My lord, they were not on caveat, my lord.
Yes,
all right, Mr. Rai, since the since they have appeared, they are not on caveat.
No problem with that, my lord.
When
Can you also hear me, my lord?
though they are not on caveat.
My lord, I'm serving it right here, right now. My lord, may kindly record it.
My lord, we can serve, my lord. My lord, kindly consider on Thursday or Friday, whichever day you fix as well.
Yes, copy of
Friday if possible, my lord.
Yes, call the next matter.
100.
Thank you, sir. My lord, I was in court room number 16.
100.
96, my lord.
Yes, yes. Please.
I was in court room number 19, my lord.
Yes, who is appearing in 100? None appears for the petition. Yes, you are in item number
96, my lord.
96. Adit. Oh, personal ground. Personal ground.
Personal law. Must.
He said the earlier civil division application between the same parties was released also earlier.
Oh, my
Yes,
lord,
call the next matter.
my lord, I am praying for apology, my lord.
101, my lord, I am for the petitioner. It is a section 24 matter.
For want of determination, let the matter go out of the list. Yes, next.
102.
This you are appearing.
I am in 101. I am for the opposite party.
This application under Article. This application under Article 227 of. Yes, next.
103.
Lordship, I am for the petitioners. ESI Corporation.
Yes.
I'm challenging two orders. Orders number 32 and 33 passed by the ESI court on 4th December 2023, where the learned trial court disposes of the 75-1 application.
Yes.
If a lordship takes the order sheet, ignoring my written objection. In the background, the opposite party number 1 has been covered under the ESI Act in the year 2000. Pursuant to such coverage, they disputed this coverage. Then C18, the show cause notice was issued. Personal hearing was given.
They did not turn up twice. Then order under section 45A was passed. In the interregnum, they failed to deposit from 2010 to November 2014. An amount of 2,57,000 and odd was due. Once is due, once a code number was given, due to the online process, they opted for another code, new code, and generated it online on 1st of January 2018, which according to me is illegal. They cannot have, a factory cannot have.
The injunction petition has been disposed of.
Disposed of, directing me to accept their deposits, accept on the new
serve
code.
a copy upon them. The petitioner is directed to serve a copy of this application upon July. Monthly list.
Much of that.
Yes. Taito. July.
Sir,
Yes.
this is against an order by passed in the section 24.
Section?
No, my lord, not sorry. Sorry, my lord, this is the against the maintenance of pendulum.
Yes.
That is the final order, my lord, has been passed.
Yes.
Judgment, my lord, your lordship, your lordship. The judgment is not originated of the law. Well, the learned food was of the view, my lord, at page, internal page 3, last paragraph, my lord. The petitioner in her affidavit of assets and liabilities has stated on oath that the child resides with her father. Well, the documents have already been annexed herein also. And he bears all her expenses. The petitioner has affirmed in her affidavit she resides at her paternal home, has no independent income. The petitioner in her affidavit, however, has not added any details of her monthly expenditure. The opposite party has affirmed that the petitioner gives dance lessons and private tuitions. The petitioner has not filed any statement of her bank account. The purpose of filing affidavit is to enable the court to get a clear picture of the income of the parties. Nothing has been declared, my lord. I was saying the daughter is being maintained by me. I have my parents also, my lord, ailing parents. I have to look after them. And my lord, the petitioner, my lord, has left the matrimonial home after filing a complaint before the police that she has been on that is our challenge in our mat suit also, my lord.
$20,000.
My lord, I will pay, my lord, 20,000.
Your income is 1,33,000.
My lord, I have given everything, my lord. This is annex also. Your lordship will find, my lord, that expenditure of the daughter totally borne by me. She is in the school, my lord, having extracurricular activities, everything.
Daughter is staying with?
Father, my lord.
Yes.
The father. She has been handed.
You will maintain your daughter. So that cannot be a ground that you will not pay to the wife.
Saying that I will not pay, my lord. I am paying 10,000. But my lord, your lordship, my lord, your lordship.
10,000 is not sufficient.
My lord, I am
not commensurate with the status of an assistant professor of a St. Xavier's College.
My lord, that is not the point, my lord. This is the point.
That is the point.
My lord,
Commensurate with the status.
my lord, the commensurate to the status, it has to be. But my lord, that petitioner, my lord, is paying, and the wife is also, my lord, earning.
The yardstick is between 1/3 and 1/5. Even if we take 1/5, it's less than that.
My lord, if your lordship, my lord, only through this, my lord, let them come and explain why the affidavit of assets has not been given properly, my lord.
Nothing.
The affidavit
I
of,
can expedite the suit if you pay that.
my lord, well, there is an execution proceeding also. That is the main thing.
You pay, otherwise there will be an execution proceeding.
But I can pay 20,000, my lord. The execution proceedings is of,
1,000 is neither here nor there.
well, 10,000 is much more because she's earning.
10,000.
My lord, she's earning. That is what I'm saying. Well, that has to be made.
Show me how have you proved that she is earning? Private tuitions.
My lord,
What document?
well, we have
What document have you produced to prove her income to private tuition?
that.
And you're earning through private tuition also.
Well,
Officer,
no, my lord, I'm not earning.
nobody says that they are doing
That has not
private
been
tuitions.
We have read it and that has been accepted by the court also, my lord, because she has not said anything. She said that I have no income, but no bank account details, nothing has been given. So, my lord, at least this much can be done, my lord, so that it can be, my lord, I am covered by the lordship knows, my lord, Akankha Jain judgment is also
What?
there. My lord, Akankha Jain's judgment is also there. That he has, by the Supreme Court,
What judgment?
my lord, this has been taken into account, my lord, in this judgment. That if, my lord, sitting at home, doing nothing, an able-bodied person, my lord, if you go on,
There are contrary judgments also.
my lord, there are.
So,
Let them show the contrary judgments. My lord, these
contrary judgments, you are well aware. You please show me the contrary judgments also. You also have a duty to show both.
my lord, I
Please
will-
show me the contrary judgments.
I will, but my lord,
As an officer of the court, when the other side is not here, please show me the contrary judgments.
that's what I'm
Have
saying.
20,000,
My lord,
10,000. It's not commensurate with the status of an assistant professor of a reputed college. Of a reputed college.
maybe that is there, but lordship may
Application.
affidavit of assets is nothing, not
কত? 5. Yes. 105. Who is appealing? Section 4 appellable order মনে হয়। দেখি এটা দেখি। Mr. Mukherjee, an order passed under Section 4 of the Partition Act is an appellable order.
Maybe under Section 8, I need to check.
I think it's an appellable order.
Just check. I'll just check. Lord, it says that orders for sale to be deemed degrees.
Yes, 2, 3 and 4.
Section 8.
Yes. But it has been rejected, so it may not be, maybe said, argued that it's not an order of sale. Section 4 rejected. Because it says that an order for sale made by the court. So, shall be deemed to be, and so if an order of,
Direct sale.
so if it is rejected,
It might be
then
revised. Yes.
none appears for the petitioner at the time of call or accommodation. Yes, তুই appear করছে না কি ব্যাপার? নোটিশ দিয়েছিলেন ঠিক মতো? Same order dismissed for default.
Next. 107.
None appears, dismissed for default.
Next.
For the petitioner, my lord. A letter was given by the opposite party for a copy. We have supplied the copy and we have also given notice of mentioning to the other side, my lord, before mentioning the matter, my lord. These are-
Who is appearing?
না মেনশনিং এর পরেও নোটিশ দিয়েছি যে
Mr. Banerjee, who is appearing?
Paulina Ghosh for the municipality. For difficult, I mentioned because my lord, the matter is not fixed for final argument. It is regarding marking of a document. Initially, my lord, first round, they filed the application for marking a photocopy, which was rejected by the court.
You have the phone number of the
Yes.
phone number. So I'm passing it over. 415 or 430?
415. 415.
415 matter আছে? 4 PM.
415.
4টের সময়।
affidavit service টাও দিয়েছে।
Yes. Yes, call the next matter.
109.
Yes, Mr. Dey, where are you looking? 109. Sirajuddin Molla, your matter has been called on, you are standing.
My lord, I am for the opposite. But I apologize, my lord. I thought it was. I am for the opposite, but I am praying for 1 day accommodation.
1 day accommodation, why? In which matter?
Matter, my learned friend is opposing. I have not seen the matter, I have seen him. 1 day accommodation. Point is, my lord, no, accommodation, I will pray more than one. So 1 day consent with consent, other day prayer. Point is very critical, I will take some time. What is the effect of non-judicial tenancy act amendment? Could it say all decree passed therein has been wiped out because of the taking over the amendment till the date of its inception? Here in the case, order passed but could not be executed. Now the execution proceeding is levied before my lord, and the order passed therein. I am saying that execution is not possible because the judgment, the decree is wiped out.
So there is no question of any stay.
With consent.
Stay was there.
Stay was there.
With
Now
consent.
Why it's the motion?
Now it is hearing.
So it has to be heard.
Yes.
So I'm fixing under the hearing.
Consent may be continued. There was a consensus. There is no consent. Consent.
What consensus?
Eki.
এটা বলিস না।
What was the consensus?
That they will not proceed for the execution. At that time, my submission was that we are waiting till 19. Yes, that's
Oh, there was no interim order.
not passed, but parties were directed not to.
That will I'm not passing any consensus between the learned advocates. To that effect, no order can be passed, Mr. Basu.
Then let me open this so that I can convince my lord.
No. So it's not a fit case because so many arguments. After so many arguments, you could not obtain any interim order.
That has been
So this is a fit case for not passing any.
my lord has experience. My lord was bar in the
From August 2024.
Justice Basu was there. Justice Basu used to hear the entirety.
Yes.
The event has been changed. It was being heard. At least কতদিন hearing হয়েছে?
So it was half substance. So I'm directing this matter and releasing this to be placed before Justice Basu.
Okay.
It was hard substance.
He's hard pressed with Sikha Dikha. He cannot.
So let it appear under the heading contested application. Otherwise,
That's true. But only difficult. I hope my lord, my learned friend will accede to his consensus with the granted.
It is expected.
After yes.
Though I had,
Dotto.
though I had, my junior had approached him.
Oh, that was the school.
Yeah.
So that matter.
English medium, Bengali medium.
And now,
Any consensus?
no, my lord, now, my lord knows the condition now of the government schools. Teachers.
So far, my instruction is.
But I am ready to bear all expenses, even for the conveyance. But what prevents my learned friend to open what?
My
Mr.
instruction
Dotto,
is
it's very difficult to decide whether it should be the English medium school.
It
Bengali
is not
medium.
Better
English medium.
school.
It is not
Better
English
school.
medium. It is
Any better school.
international school, not English medium.
And I do not press for that particular school.
It is the order.
Even Ramakrishna Mission, even wherever.
It should be international school.
No, it was a suggestion. It
No,
was
it's a
just
suggestion international English
Not
medium.
suggestion,
school.
my lord. Page number 52.
You are for the wife.
Wife. My lord,
Okay.
my instruction
So,
is.
yes, where the child is now studying.
My lord, right now it's studying in Murshidabad, Jiaganj.
Yes.
It is a very well-established school where, my lord, he has been right now studying. My lord, it is a school, my lord.
The Bengali medium or English medium?
It is a Bengali medium school.
So, Dotto, it's difficult if you change the medium of
8
instruction.
years,
Or
8 years,
Which class?
8 years.
Age 8 years.
It be difficult.
8 years, 2 or 3. Now, if
So, doctor, I do not know if the child finds difficulty by changing.
as a father, should I not
Schools are not good according to you.
No,
All the
definitely good.
everything
Definitely
studies
good. Very good infrastructure. Everything good. But as a father, should I not expect my child to get better amenities, better education?
No, better amenities, better education. Yes, Mr. Dotto, but changing the instruction, that is what is troubling.
If not now, then when? 2 or 3, she or he is reading.
Yes, Mr. Rai, why cannot?
But my submission before your lordship, my lord, as instruction that I have received, that she says that entire childhood friend, everybody, the neighbors, my lord, children, everybody are studying over there, and different scholars who have been, my lord, laureated from that particular school. Even I have been instructed to submit to your lordship that son of Arijit Singh also studies in that school.
That is neither here nor here. Why is she opposing to it? I do not know. I would be.
So if he can, if he or she can be admitted to a better
Yes.
school, why are you opposing to that?
My lord,
If it is a better school, suggest any better school.
They may suggest.
Yes,
They may suggest.
my instruction, my lord, is today. On the earlier date, when my lord, my learned friends, my lord, client, my lord, tried, or my learned friend, my lord, tried to contact with my client, they could not talk only because of the reason of my lord's examination of this child.
All right. So now the examination is over.
It is over.
So now it's the examination is over.
Once again.
So both of you suggest maybe in the same locality, maybe in the same
Let them
locality.
do that, my lord. This is I on the earlier occasion also, my lord, I proposed that.
Yes.
Let it be done. If they, my lord, could come to an
Doctor, in the
consensus, that
same
would be better.
locality, if it is.
Yes, I have no
I just
objection
do not
to
want to
that.
take this response.
Suggest the name of a school in that locality.
If my learned friends' clients can suggest, I would agree to it.
Better school.
Better
according to you.
Yes.
My lord, let them just talk, my lord, because on the earlier time,
Clients are not in talking.
Who will talk?
Clients are not
my
in
lord,
talking.
they have approached, my lord.
Sir, both of you talk about
Yes.
yourself. You take instructions, a better school. I think because the parties are not on talking terms, both of you are on talking terms.
The advocates on record of either side.
Both of you take instructions, a better school.
Within a short time, I would kindly do not.
দেখো যদি কিছু করতে পারো। আমি তাতে কিচ্ছু বলতেই পারবো না দেখি। এদের যেটা ডিসিশন এরা করবে আমি এর মধ্যে কিছুতেই করতে পারি।
In order to explore the possibility of the child being admitted to
Let them suggest.
School having better facilities
And
than the
amenities.
present school, the hearing of the matter stands adjourned for 2 weeks.
My prayer is preferably medium is English. My prayer. If
Doctor, if she also agrees to that, that is a good thing. But consider, because it's the welfare of the child.
Yes, but that is the reason I am agreeing.
Medium of instruction, if it
If
is changed, I do not know
if
how
I
the
do not change now,
child will be able to cope up with that.
if I do not change now, then when, my lord? At least this.
If you want, I can appoint a mediator for this.
Mr. Chakraborty is there.
Mr. Chakraborty is there.
Yes.
For mediating.
For this purpose, Mr. Chakraborty is a better candidate.
I will tell you one experience I had.
Yes, yes. Yes, call the next matter.
People one.
matter.
ডেটটা কবে?
Yes.
ডেটটা কবে রাখা?
2 weeks, 2 weeks.
Yes.
Lord, I appear for the petitioner.
I'm for the opposite party, Mother.
This is the petitioner, Lord. I tell you also what happened. I filed this active case, Lord, on 12th of September 2022. Lord, kindly comes to first page, Lord, 34 of your Lordship's brief once. Page 34.
Visitation right modification.
Yes, that has been modified. How it has been modified? Kindly see the direction earlier, page 30. And the father. Kindly come to page 30.
You are the father. Child is with the mother.
Yes, I am the non-custodial parent. Kindly take page 30, the original order.
38.
38. 12th September 22. Has got that. 39. Petitioner shall visit his son on every fortnight on Sunday on 1 p.m. to 6 p.m. in the house of the respondent. At that time, interaction and meeting petitioner with his son. No one will interrupt.
Every fortnight on Sunday.
Sunday, 1 to 6 p.m. in the house of the mother.
Mother, yes.
Then kindly see the second portion. The petitioner shall resume video calling from the minor twice in a week, Monday, Wednesday, Saturday. Then the third, in the vacation, the petitioner is permitted to meet with the son once in 7 days, and the day meeting shall be fixed mutual agreement. In the vacation, petitioner can take his son to any place, play or park and shopping mall, etc. But in that case, the respondent will accompany them, and the place of visit shall be fixed mutually. This was the direction.
Yes.
Now I was facing some difficulty going to wife's house. My lord knows there will be a lot of interruption. I filed an application. Just tell your lordship the application that I filed. Your lordship will get that at page 40.
So that application was disposed of.
No, the application was decided with an application filed by the wife. I filed the application, page 40. I said that you allow me to take the child, page 47. Application that I'll take him one day to my house and return the next day, page 47. That was my application. I have got that, page 47.
Yes.
Now just take the pen to come to only one page. 77. My application was kept along with wife's application. Wife filed an application, Lord, sometimes in 2024, saying that I have created a difficulty while visiting the child during the vacation in a mall. Page 77, can you see once? Page 77, ordering portion.
Yes.
20th July for hearing of the application filed by the respondent mother regarding modification of the order of visitation as well as the prayer of the father for modification of the order.
Yes.
Now my application is
it was both the applications were
my application has not been touched. But not been touched.
You want modification?
Yes. Now I wanted that instead of going to her house, I'll bring the child one day to my house and return.
Yes. No, what happened to these applications? Now it has been disposed of.
My application has not been touched. Her application decided on the ground that I will go to back to court and meet the child. Kindly come to the impugned order.
Court.
Impugned order,
11th November.
11 November 24 order. The impugned order. Mother says there was a difficulty one day faced in a mall, and on that application, without considering anything, the court says, see, 3 p.m. to 5 p.m. on every first Saturday and third Saturday of every month, I'll go to a courtroom and visit my son. A court is not a happy place to visit my son.
What treatment the child is getting?
Lord, the mother says the child is suffering with attention deficit hyperactivity disorder. Lord, all of us in our childhood, Lord, we were very hyperactive. So he's an American citizen, the child. Lord, both of us are IT company. We were there in America, Orlando. The child was born there. And Lord, then we came back. I am in Bangalore.
Born there.
Born in America.
Child is an American citizen.
By birth.
The child
by birth. Now that is one of the fear. That is why we immediately lost the case so that she cannot take him out. Now, Lord, what is happening is I stay in Bangalore. So there in Rajarhat. She stays in Boranagar. But I said, I prayed that you allow me to bring the child to my house. In that day, I will return him. That was my application, not even template. Her application, kindly take the application. Which I
may not be an congenial atmosphere for keeping of the child.
Not also brief into this matter, my lord. I've been only instructed to seek adjournment for the day, my lord. And kindly, my lord. My lord, let them come with a copy, my lord, so that we can.
You have not given him a copy.
There is no caveat.
All right, give him a copy.
Lord, I'm giving him a copy by tomorrow. Keeps it, Lord. This can be decided by your lordship, Lord, immediately, Lord. Instead of keeping it pending, my lord will return it back, and both the application will be decided. Let me come back.
When this matter is taken up for hearing.
To I appear for the petition.
Appear for the opposite party.
By the impugned order, my lord. So by the impugned order, my lord, the landed court below, my lord, rejected the prayer for using the secondary evidence on the ground that, my lord, the ingredients have not been fulfilled.
On the ground that
For using the secondary evidence.
foundational basis for leading secondary evidence has not been so rightly rejected.
So, my lord, what I make submission to your lordship, my lord, kindly have a look to page 50, my lord, the cross-examination of the, my lord. Everything has been stated, my lord.
Page
50.
50.
The first paragraph, my lord. This is the photocopy of affidavit sworn by Ashutosh Kaur, Gauri Kaur and Pramod Das Kaur before Executive Magistrate, Hajoi, Assam. The original affidavit is lying in the custody of the defendant. I was present at the time of photocopy of the affidavit. I have compared the photocopy with the original affidavit. I was present before the notary public. The photocopy of the affidavit was given by my adopted father, Ashutosh Kaur. Well, this is suit for, my lord, eviction. Well, the adopted parents were the owners of the, well, the suit property. So, my lord, after, my lord, their demise, my lord, the petitioner, my lord, inherited the suit property. And, my lord, the petitioner, my lord, submitted, my lord, one photo.
Where is the original document?
Well, that is lying with the defendants. I have stated.
Have you given a notice to produce?
That has not been, my lord, done, but I have stated, my lord. I have stated on oath. I have stated on oath, my lord, that those are lying in the. My lord, I filed an application for inventory. Well, that was also rejected. Lordship can have a look, my lord. The prayer, my lord, page 97, my lord. Page 97, Lordship can have a look, my lord. I prayed for inventory by, my lord, appointment of any commissioner. That was not considered, and, my lord, that was rejected.
What is the document? What is the photocopy of?
My lord, if, to prove that the, my lord, petitioner is the, my lord, adopted daughter of our parents, my lord. It was, my lord, affirmed before, my lord, executive magistrate at Assam.
So the evidence is over? No.
Evidence is going on, my lord.
Argument stage.
Argument stage.
No,
Yes, Mr. Vadajaji.
Two things, my lord. First, my lord, from the since inception, this document was not placed. Oh, they have filed.
Is it lying with you? He says it's lying with you.
No. From inception, in the application for
kind of a licensee.
They are claiming that they are adopted son, adopted daughter. Even in the voter card, even in the birth certificate, even in none of the documents, the name of these parents are there, my lord. Only this Xerox copy of affidavit which they are residing here. In the injunction application also they have resided the Xerox copy, and which was the injunction was turned down. They have filed application for inventory commissioner, that was also turned down, and they never challenged before in revisional court also. Even in the plaint itself, this fact which are stating in the cross-examination, this is not being stated in the plaint also.
all along they were aware that the Xerox copy was there in the record. Now they are making a fresh story saying that at the argument stage they come to know that that was not exhibit.
It is not the story, my lord. My lord, in the plain it has been stated that, my lord, I have, my adopted daughter parents were, my lord, the owners of the property. And my lord,
you have a copy of the Evidence Act?
Yes.
That's it.
Now,
Yes, I've got.
yes.
Where have you stated that it's lying in the custody of the defendant?
Well, in the cross-examination, I have stated, my lord.
In the present file, not his.
Well, at that time, it was, my lord, not, my lord, relevant for, my lord, for stating all these things. My lord, after, my lord, ascertaining that it is not lying with the defendants, my lord, I categorically, my lord, file an application for, my lord, commission, inventory through commission. That was not considered. And, my lord, when, my lord, initially the photocopy was, my lord, exhibited, it was not marked.
Where have you stated that it's lying in the custody of the
Well, in the cross-examination, I have stated.
Show me.
Page 50.
50.
Third line, your lordship can read. The original affidavit is lying in the custody of the defendants.
Page 50, the original affidavit.
No, take it.
Why? What is the occasion for this original affidavit to lie in the custody of the defendants?
Hello?
Why this original affidavit will be in the custody of the?
At the time of, my lord, making it, my lord, what happened in this, my lord, case, my lord? They are, my lord, the distant relations with the, my lord, the adopted parents of the, my lord, petitioner. So, my lord, during lifetime of the, my lord, parents, my lord, they started living with the parents. Now, my lord, after the death, my lord, the petitioner, my lord, requested themselves to, my lord, to vacate the suit premises.
Yes.
They refused to, my lord, do so. So thereafter, my lord, the petitioner was compelled to, my lord, to file a suit for eviction, my lord, of a trespasser. So, my lord, at the relevant point of time, my lord, the, my lord, original, my lord, biological parents of the, my lord, the petitioner, my lord, they, my lord, affirmed on affidavit before the executive magistrate at Assam. And that was, my lord, copied through, my lord, mechanism. So a photocopy was done in presence of the petitioner. My lord, the petitioner categorically stated that. So, my lord, section, my lord, 65, my lord.
Yes.
Subsection C, my lord.
What do you say to section 66?
My lord, I file an application for, my lord, for making inventory, my that is, my lord, treated to be as notice, my lord. Because at that time, my lord,
that was rejected. That was accepted, that order.
That was rejected, my lord. But at that time, my lord, I raised this question, my lord. That would be, my lord, deemed to be section, my lord, 66, my lord. Because, my lord, I brought that, my lord, fact before the learned court below. That, my lord, the original is lying with the defendant.
You have to give notice to the other side.
My lord,
that is the law.
My lord, I filed the application for, my lord, making inventory. My lord, that is, my lord, kindly, my lord, to appreciate.
Where is that application?
The kindly comes to page 97, my lord.
And where is the order passed on that?
97. 97.
97 is the order.
Yes.
My lord, application, my lord, is, my lord.
You are the plaintiff.
I am the plaintiff. Wait a minute.
Where is your application for inventory commission?
That has not been annexed. That is not annexed.
Show me that. Please bring that. The learned advocate appearing for the petitioner is directed to
Not,
yes.
not this is the order under challenge is passed by the NCDRC in an appeal filed against the order of the State Consumer Forum. But what happened, I tell you. My wife was admitted under the opposite party number 1.
What is the order passed?
Lord, the compensation has been enhanced, Lord, from 10 lakh to 25 lakhs.
10 lakhs to 25 lakh.
12 lakhs, but 8 lakh against the doctor was made to 15 lakhs, 4 lakh was made to 10
More than that.
But I tell you also what happened.
You want more than that?
Of course. But it was not.
Mr. Chakravarti.
Of course I have to serve. What happened? My wife.
There is no scope to pass an interim order.
There is no scope to pass an interim order. But what I want is, I want the doctor should be before your lordship an expeditious disposal of the matter. Not a contaminated blood.
No, expeditious disposal of what matter?
This revision, Lord. A contaminated bottle of blood. Lord, he ordered 5 packets.
Can that issue be decided by the consumer forum, or that is other forum to decide?
All other forums decide. Yes. The medical council, the disciplinary board hold him liable. Ethics committee. What he did, you know, he ordered 5 bottles of blood. 1 bottle was kept in the normal freezer with tea and coffee. He injected that immediately. The patient died on the table. It's not about how much the wife used to earn. It is about not the nominee. My lord.
Yes, call the passover matter.
Actually, 111 you lordship kept the next week. Lord, next week, today is a Monday. Next Monday is monthly list. 111, 6th. 6th is on.
I was conscious of that. I was fixing 5th. You are busy. You are thinking of other matters, Mr. Chakravarti.
Now it's stuck.
But this is my application. I am the defendant in a suit for a declaration.
Caveat is there.
There is a caveat. My learned friend has served, Lord, I am told.
Have you informed him?
কোথায় এভিডেভিটের সার্ভিস কোথায় কিভাবে জানিয়েছিস বাবা
Who is there? You have the mobile number?
Oh, I am told, Lord, that he generally practices at Howrah Court, the learned advocate.
It is delivered. Who has lodged the caveat?
Yes. But it appears to have been delivered, Lord.
So this is by registered post.
Lordship, but speed post with it.
Yes.
Lord, I can hand over, Lord, the affidavit of service.
Evidence. Yes, Mr. Mukherjee.
But I am the defendant number 1 in a suit for a declaration of title. The plaintiff says the plaintiff is a part owner of, Lord, a particular property. Admit
the absolute owner.
No, I am a part owner. The dispute is, Lord, So far as the
Part
title,
owner or co-sharer?
I am a co-sharer along with blood the other parties to the suit. Plaintiff is not a co-sharer. Defendant, my client is the co-sharer. The pro
There are
forma
other parties
defendant,
also.
yes. The property is 27 decibel. Now, blood, it appears blood for
What
the
is the
deed.
suit for?
For a declaration of the plaintiff's right so far as A1 schedule of the property is concerned, which is not, they are marked in the plaint in the map.
Not partition.
Not for partition. There I will come where your lordship is blood absolutely right. I'll eventually blood come to say about blood whether the injunction could have been granted in a suit blood which is apparently blood not maintainable. Now what happened? The plaintiff blood, they say that they have purchased blood 9 shatoks of property which will be apparent from their deed. But blood, their names were recorded in respect of 7 point something blood.
Wrong recording.
Wrong recording. Now, blood, so far as my clients are concerned, blood, I purchased blood 7.34 blood shatak of land, whereas blood it is recorded at 9 shatak.
So it's a reverse.
Reverse. Theirs, it is purchase is more, recording is less. My purchase is less, recording is more. Now, blood, the learned judge passed an order of not the status quo. In the meantime, why the status quo affecting me? Because in the meantime, blood, I have already obtained a sanctioned building plan showing that my area of land is 7.34 blood shatak of land.
The area which you have purchased.
Area which I have purchased.
As per the deed.
Yes. Although there is one catch. When we applied for blood, this was a doba. When we applied for conversion, he applied for conversion in respect of blood. He means the plaintiff. In respect of blood, there are lesser quantity of land. And I applied
the record of right.
As per the record of right. And I
applied for conversion as per the record of right.
Yes. Now the difficulty now here is, Lord, because of the status quo order which has been affirmed by the appeal court, which operates only against the defendant number 1, my client, Lord, my construction in respect of Lord, the remaining property, although I'm not covering Lord, the disputed property, that is affected. For that reason, I am before your lordship. Now, one by one, Lord, I'll take your lordship, Lord, first with a prayer.
So this is a temporary injunction disposed of or added?
No, not added, on contest. Temporary injunction. Kindly have a look at Lord first, Lord, the prayer. That is that your lordship.
There is no scope to pass any interim order.
I know, Lord, there is a grant against a grant. Lord, I am coming up before your lordship.
But there is a caveat you have served, but can it be disposed of finally in their absence?
Ideally, Lord, if they were present, it could have been, Lord, and I would have made it, Lord, a short up, Lord, a point of argument.
What do you propose?
If your lordship, Lord, post it to some other date, we can, Lord, intimate the learned advocate that your lordship has, Lord, indicated.
This is the difficulty. If the caveat is lodged by...
Lord, but eventually your lordship has experiences, Lord.
Here it could have been informed, and that is why I was asking that whether the...
Even by design, Lord, sometimes, Lord, it is done.
Yes, most so since the
injunction was obtained.
The earlier trend was that advised not to lodge a caveat in this type of matters, but they have lodged a caveat.
Yes.
So I think, but that does not work now.
No, it doesn't.
Affidavit of service filed in court today is
My defendant's application for expeditious disposal of the injunction application only.
This application under article.
Kindly comes to page 58 for once. There's a page 58. There's an earlier order.
Till now, it has not been disposed
What
of.
had happened, my lord, the learned civil judge senior division first court is lying vacant since the earlier presiding officer has retired. My lord, kindly sees the last 5 orders certified.
Then what can be done?
No, my lord, what had happened, there's a second court is in charge. But the second
court, it's difficult.
Unless my lord directs the charge court to take up the hearing. The injunction.
Charge court is having his own file.
My lord.
There may be some expeditious. Charge court, it's difficult.
With regard to only injunction disposal of it is data ready for hearing otherwise.
It's difficult.
My lord, kindly.
Charge court, it's
I'm
difficult.
not praying for the entire suit to be expired. I'm only praying since I'm suffering an injunction order, my lord. That's why. There's a construction work which has been stopped due to this injunction order, my lord. Now kindly see the last 5 orders. Identical order. PO has retired.
Cannot be held because injunction, it is to be a contested hearing.
Yes.
So it will take also time. It's not that the presiding officer, she will be busy with her own file.
But that does not mean I'll be rendered helpless, my lord.
That is one thing, but let it be taken.
The last 9 months, the court is lying vacant, my lord. I'm absolutely helpless at this point, my lord. Otherwise, I wouldn't have come, my lord.
Has not yet joined.
My lord, there's an order of appointment, but he has not joined yet. There's no no further notice as to when he will join.
What is the next date fixed?
13th of May.
This application under Article 2 Yes.
Please, my lords, Lord. Item 115, Lord.
My lords, I'm appearing for the petitioner. I'm being led by Mr. Pinaki Mishra. He's online.
Lord, I'm privileged to appear before your lordship.
Yes,
Lord,
yes.
I'm sorry. I'd come to Kolkata, my lord, on the 28th. Unfortunately, the matter didn't reach, my lord. Therefore, I didn't have the pleasure of appearing in person before your lordship, my lord.
Yes.
But today, if your lordship permit me, my lord, may I appear online?
Yes, 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 no problem. Yes, you can move online.
I'm grateful. So, my lord, this matter, my lord, comes from the NCDRC, my lord. It's a 220, Article 227 writ petition. Would your lordship, my lord, it's a very short point. I think I may be able to convince your lordship just on this short point alone. Page 28, the impugned order. Would your lordship just see the first page of the impugned order? In Nishit Bariyar, my lord. I think the matter listed today is Nishit Bariyar. That's the first matter, my lord. Page 28. Do your lordship have page 28, my lord?
Yes, yes.
My lord, would your lordship kindly see on the top a judgment reserved on 27th of June 24. And my lord, eventually it was pronounced on 27th of December 24. Now, my lord, my colleague there will give your lordship a judgment compilation, my lord. In between, your lordship will find the Honorable Supreme Court, my lord, Justice Hima Kohli and Justice Sandeep Mehta on the 28th of August 24. The first judgment, my lord. On the 28th of August 24, my lord, their lordships decided, if I may just read through this, my lord, it's a very short one-page order. If your lordship kindly see, paragraph 3, my lord. At this stage, Mr. Pajoshi Leonard, senior counsel appearing for the appellant, draws the attention of this court to the impugned judgment to urge that the same has been delivered by a sole non-judicial member of the NCDRC, which is not permissible as the quorum cannot be treated to be complete. The submission made by counsel is borne out from the record. Impugned judgment has been passed by a single member of the tribunal, and the quorum being itself being incomplete, we are of the opinion the matter ought to be remanded back to the tribunal for a fresh decision. Needless to say, the records available with the tribunal shall be relied upon, etc., etc. And for a decision, my lord, to be rendered by a bench comprised of a proper quorum. Impugned judgment is quashed, set aside. The parties.
It's also by a single member.
That's right. Your lordship will kindly see page 28, Mr. Honorable AVM, my lord, Air Vice Marshal J. Rajendra AVSM, VSM retired. Now, my lord, most judges in the Honorable Tribunal realized when this judgment came and they had heard the matter singly, they, my lord, in fact, immediately recused themselves and said these matters have to be reheard. My lord, this gentleman, unfortunately, my lord, went ahead and passed this order. Now, this is completely in the teeth of the Honorable Supreme Court's judgment, my lord. So, he's completely non-jurist, my lord, quorum non-jurist is writ large on the face of it. So, my lord, I don't think I need to trouble your lordship anymore. On merits, I have an outstanding case. But, my lord, why should I trouble your lordship? The matter will have to be remanded back to be heard by a proper bench of proper.
Remanded after giving them notice, because
as your lordship pleases. As your lordship pleases, the only thing, my lord, then let there be no further proceedings before him. So your lordship will kindly, my lord, stay all proceedings before the NCDRC.
What happened on 17th of February 2025? It was the next date fixed. For final arguments. What happened?
They've adjourned it, my lord, to 9th, my lord. I think the other side wanted time, so they adjourned it to 9 July, my lord. So the matter is coming up on 9 July.
Final arguments have not been made.
Not yet, my lord. Not yet.
This application under Article 227 of the Constitution of India is directed against an order dated December 27, 2024, passed by the learned National Consumer Dispute Redressal Commission in first appeal number 351 of 2019. Full stop. On a bare perusal of the said order, it appears that the said order was passed by a single member of the commission. Full stop. The learned senior advocate appearing in support of the application places reliance upon a decision of the Honorable Supreme Court dated
28th August.
Places reliance upon an order. Places reliance upon an order of the Honorable Supreme Court dated August 28, 2024 in Civil Appeal number 3953 of 2018 in the case of Tiki Tar Industries versus National Insurance Company Limited in support of his contention that an order passed by a but the presiding officer is a judicial member.
This gentleman in any case is a non-judicial member, my lord, because he's retired from the armed forces. So he's a single member anyway, who's a non-judicial member, exactly as in this case.
Oh, so presiding member is a non-judicial member.
That's right, my lord. That's the difficulty.
কি বললাম? A sole non-judicial member of the National Consumer Dispute Redressal Commission is non-est in the eye of law, as the same is not permissible, as the quorum cannot be treated to be complete. Full stop. In view thereof, তারপরে লিখুন, on a query of the court, the learned senior advocate appearing for the petitioner submits that the hearing of the matter was adjourned till 9th
July 2025.
till 9th of July 2025. Stop. Paragraph, there shall be an order of stay of all further proceedings in first appeal number 351 of 2019 pending before the National Consumer Dispute Redressal Commission at New Delhi. So no bench has been mentioned, so it's the only bench.
This is the bench below before which it will come back. So therefore,
till the end of June 20, till the end of the month of June 2025 or until further orders, whichever is earlier. First up, list this matter under the heading motion in the monthly list of June 2025. Petitioner is directed to serve a copy of this application upon the opposite parties by registered speed post with acknowledgement due and file an affidavit of service on the next date.
there are 3 other connected writs, my lord. The same order, same impugned order, same gentleman, my lord. Those are listed in the monthly list. I won't trouble your lordship today, my lord. As and when they come up, my lord, the same orders will follow. My colleagues from Calcutta and Company will trouble your lordship with that, my lord, if your lordship permit, my lord.
Thank you.
Very great privilege to appear before your lordship, my lord. Privilege. Grateful.
Yes, next.
416.
My lord, I am appearing for the petitioner. My lord,
Opposite party.
my lord, suit for declaration, partition and injunction filed by the plaintiff. My lord, injunction order was passed. My lord, status quo order was passed. And thereafter, my lord, they filed an application under section 151. The injunction application in the 151 were all along heard together. But my lord, on the last occasion, my lord, the order dated 19th of November 2024, the learned judge passed an order that no, first of all, we will hear the injunction 151 application, and if time permits, thereafter.
What is the 151 for?
151, my lord, this is pertaining to a garage. A family settlement was there.
151, what is the prayer in the 151?
My lord, prayer is, my lord, please to direct the officer in charge, Jadavpur Police Station, to implicate the status quo order dated 6/8/2020, passed by learned 5th Civil Judge Senior Division at Alipur, says strictly, and to pass such other or further order. My lord, my only prayer is that, my lord, let the injunction application and the 151 be heard simultaneously, my lord. Because the 151 as well as the injunction application were all along heard together.
Yes.
Now, my lord, I filed order 39 rule 3A, my lord, that was rejected, my lord, saying your lordship kindly seize the order. If time permits, the application will be heard.
Injunction application is ready for hearing.
Everything is come.
It's ready for hearing.
What is the next date fixed for hearing?
The next date fixed is 7
May,
in the month of May, my lord. If on that date the injunction petition is heard, I have no difficulty, my lord.
Yes. The You are for the defendant.
Yes, my lord. Without, before admission, they have served me the notice. So I am the plaintiff. I have appeared.
I have served notice.
No, my lord, the difficulty was, my lord, the last date was on 7.
Maybe I have served a copy without a direction from the court.
No, my lord, because on the date
not have served.
My lord, the date of the court below was on 7.
That he will serve.
And your lordship was in not session of the matter, my lord.
Maybe
There would,
without a direction you could not have served.
my lord, this is my fault.
Where is your application under Order 39 Rule 3A?
My lord, it is appearing at page my lord, page 67.
So it's a defendant's application for injunction.
Plaintiff. I am the defendant in that suit.
Yes. So page 67, this is the application under Order 39 Rule 3A filed by the defendant.
Filed by the defendant. Well, that's
Yes, what is your prayer?
My prayer was, my lord, both the application to be heard simultaneously. Only this much. I am not saying that 151 to injunction to be heard first. Because ultimately, my lord, if I succeed, well, the 151 goes, my lord.
This application under Article 227 of the Constitution of India is at the instance of the defendant praying for a direction upon the praying for an and is directed against an order being order dated 5th of February 2025 passed by the Learned Civil Judge Senior Division 6th Court at Alipur in title suit number 371 of 2020. First up, the opposite party filed an application under Order 39 Rule 1 and 2 of the Code of Civil Procedure. First up, an ad interim order was passed.
Yes,
Ad interim order was passed.
Where is the ad interim order?
My lord, ad interim order is at page 27.
The Learned Trial Judge passed an ad interim order on 6th of August 2020, directing the parties to maintain status quo in respect of the suit property with regard to possession / share, structure, nature and character of the suit property for a limited period. First up, this 151 was filed by
the plaintiff
for implementation.
Yes,
for implementation.
The opposite party filed an application under section 151 of the Code of Civil Procedure praying for implementation of the ad interim order of injunction through police help. First up, paragraph. The learned advocate appearing for the petitioner submits that the petitioner has entered appearance in the said suit and has filed a written objection to the application for injunction as well as the application under 151. You have also filed a written objection.
No.
As well as now. Filed a written objection to the application for injunction.
Yes, madam, we have filed objection to the 151 also.
As well as the application, as well as against the application under section 151 of the Code of Civil Procedure. So the grievance of the petitioner is that the hearing of the injunction application has been postponed till the decision on the application under section 151 of the Code of Civil Procedure. First up, the learned heard the learned advocate for the opposite party on such submission. First up, paragraph. Since the injunction application is otherwise ready for hearing, this court is of the considered view that the interest of justice would be subserved if the injunction application is disposed of expeditiously and thereafter the application for implementation is taken up for hearing. First up, what is the next date fixed?
In the month of May, I'm sorry.
Uniformly submitted. It has been submitted by the learned advocate for the petitioner that the next date in the suit has been fixed sometimes in the month of May 2025. First up, in the light of the aforesaid submission made by the learned advocate for the petitioner, CO number such and such is disposed of by requesting the learned civil judge, Senior Division 6th Court at Alipur, to take up the hearing of the application under Order 39, Rule 1 and 2 of the Code of Civil Procedure on the next date fixed, and to dispose of the same as expeditiously as possible without granting any unnecessary adjournments to either of the parties. First of all, after disposal of the said application, the learned trial judge is further requested to take up the hearing of the application under section 151 of the Code of Civil Procedure and to dispose of the same in accordance with law after affording a reasonable opportunity of hearing to the respective parties.
Then let the defendant not abide by the interim order.
There is
Because
also, I am already abiding, my lord. For the last 5 years, I have not parted with the possession.
Till and by passing a reasoned order.
Grateful.
Yes,
Great.
next.
117.
My lord, this in its very nature is a matrimonial suit. What happened? I'm the husband. I filed a matrimonial suit for divorce way back in 2018. Thereafter, my wife, who is the opposite party, the defendant, files a written statement along with a counterclaim.
What is your suit for divorce?
Mine is a suit for divorce.
And the counterclaim is for
Counterclaim is
restitution.
also for a suit for divorce. And now, my lord, there have
On
been
different grounds.
cruelty, mostly. So
Yes.
parties are alleging cruelty, and my lord, I will take my lord to the sum and substance of the counterclaim.
Why both of you do not go to mutual consent divorce?
My
Since
lord,
both of you want divorce.
my lord, that is where I am, my lord. My lord, now what has happened is in between.
So why the counterclaim was directed to be withdrawn?
That is why I'm before your lordship. That my lord, just give me 2 minutes.
But you are the
I'm the husband. I have not filed any application for withdrawal. The wife has filed an application for withdrawal of counterclaim, and at a stage when rights had already vested in me. My lord, there has been several.
What rights?
My lord,
Counterclaim,
demonstrate 150.
withdrawal of, that is nothing but a suit. Suit, anyone can withdraw that.
My lord, I will demonstrate. My lord, if my lord is little patient with me and allows me 5 minutes, gives me 5 minutes, I will explain how. My lord, what happened was the impugned order is in page 71. In page 71, if my lord comes to the last part of the impugned order,
Page
71
of
my petition. Since the dispute, the last part, this is right before accordingly the petition filed by the respondent wife is allowed. Since the dispute is matrimonial in nature and not like all other suits, and since the wife is willing to stay with her husband, in my view, an opportunity should be given to her to contest the suit, and she should be allowed to withdraw her counterclaim. Now, my lord, comes to my application. There has been absolutely no intention, no genuine intent by the opposite party to withdraw to cohabit with me at any point of time. How can this be proved, my lord? My lord will take a look at the written statement and the counterclaim. This is at page 24, my lord, and the nature, if my lord comes to page 28, where the counterclaim starts. This is fused. It is impossible.
Can the court force a party to proceed with a suit?
My lord, I will.
If not.
But courts have to be circumspect, my lord. This is what and my lord, I am protected by.
If the wife, assuming that yes, the counterclaim is not allowed to be withdrawn, wife does not appear, it will be dismissed for non-prosecution.
No, but wife is, my lord, wife is appearing. Wife has appeared.
Maybe,
but
if she chooses not to proceed with the counterclaim.
But my lord, on the basis, I understand.
If chooses not to proceed with the counterclaim, what the court will
understand
has to be dismissed for non-prosecution.
I understand my lord's concern, but my lord will appreciate that the wife has already taken. She cannot be allowed to approbate and reprobate at the same time. There is a 151 application for maintenance on the basis of
151 application. Even if the counterclaim goes, your suit remains. So she is entitled to claim.
Application where she has relied on sum and substance of the counterclaim.
That
and my
remains.
lord, I am protected by this honorable court and the honorable Supreme Court's judgments. Let me place those before my lords.
Yes. Counterclaim cannot be withdrawn.
Counterclaim can be withdrawn, but it is not an automatic right. This is a settled position.
Show me
This is
the
not-
decision. Show me the decisions.
My lord, first is Shomika. This is Calcutta High Court's judgment. দুটো কপি চলে গেছে, sorry.
If you are Supreme Court, give me the Supreme Court decision.
My lord, this absolutely fits. Here, the wife, the facts are somewhat similar yet different. The wife was allowed to withdraw the suit with the liberty to file.
It's a different thing altogether.
No, my lord.
Plaintiff at times abandon a claim, but the counter claim has to proceed.
No,
It's a different thing altogether.
My lord, no, my lord. My lord comes to the court is not finding any illegality with the order impugned in the application, where the learned trial court had rejected.
This is withdrawal with liberty to sue afresh. That is a different thing.
My lord.
Here no liberty was sought for.
My lord will.
Here no liberty was sought for. Madam, there is a distinction with this.
My lord, I will. My lord, I will. My lord, if my lord allows me to explain, the Honorable High Court did not set aside the order of the learned trial court and stated that it did not find any illegality in the order impugned because as the application for withdrawal does not disclose any reason at all. I am on that point, my lord. Now, in my application, page 71 in the order, my lord, the alleged reason for granting the wife the right to the liberty to withdraw is not part of the wife's application at all. Not just that, my lord, even before that, she has multiple times, she has filed several applications. She has filed, for example, she filed an application under Order 6, Rule 70, stating she wanted to revive her conjugal life. This was in as early as 2024. Thereafter, she withdrew that, and she has been doing this constantly with the sole objective. There's a certain mischief in the manner in which this the suit has proceeded. She has filed numerous applications and she has withdrawn. I can take your lord to these, and I had also earlier come before this honorable court praying for a speedy disposal, which was allowed. But even after that, my lord will see that she has constant. So there was an attempt for reconciliation by the learned trial court. That attempt to reconciliation failed. I have made it part of my pleading. I have annexed the necessary order as well. There have been several applications, starting with first a counterclaim where she which is in the nature of a fused application. If my lord takes a look at the written statement and the counterclaim, they're fused. It is impossible to segregate and separate the two. So if the counterclaim, and here it has not been given a separate number. So if the counterclaim goes, automatically the written statement will also goes. But so that is one point. In the counterclaim, she has
Take that point, she will be defenseless. I'm not on that. So it's only
my lord,
make that argument that if the counterclaim is withdrawn, written statement also goes.
I have made that argument before the learned trial.
So that has not been decided. So now it's only the withdrawal of the counterclaim.
So that application, her application of withdrawing the counterclaim, on which I submitted my response, and there has been a contested hearing upon which her application for withdrawal. Order 23, Rule 1, my lord will appreciate that this does not fall within the remit of Order 23, Rule 1 does not specify or does not suggest at any point of time that it is an immediate, automatic, intrinsic right. It is in fact, courts have, including the Honorable Supreme
Do you
Court.
have any other authority? I've seen that.
I have several other authorities.
Yes.
Case Bhupati.
Civil Procedure Court. Civil Procedure Court.
My lord, K.S. Bhupati, and then I will show.
All these are judgments which you are citing with liberty to sue afresh. There is a distinction with liberty to sue afresh and without liberty. All these decisions are with liberty to sue afresh. There is a distinction.
My lord, in fact,
does not have an automatic right for liberty.
My lord, let me place.
Have any decision where
I have
Liberty was not sought for.
None of
And
these.
the permission to withdraw was
What is
rejected.
case Bhupati does, and this is exactly what also Shoma De, this is the other, Shoma De, which is the Calcutta High Court decision, where several Supreme Court decisions have also been cited. What these try to do is, there is a distinction made. In Shoma De, for example,
You are also with liberty to sue afresh.
my lord, please come to para 5
Yes.
in Shoma De.
Yes, yes.
Please come to para 5. This court is fortified by the judgment passed by the division bench of this court in the case of Udaypal versus Mitrapal, reported in etc., and the judgment of Apex Court in the case reported in AIR 1973, etc. In the said case, the Apex Court considered the issue about Order 23, Rule 1 of the Code of Civil Procedure vis-a-vis non-consideration of any vested right prior to withdrawal of the suit, and accordingly held if any vested right comes into existence before the prayer for withdrawal is made under Order 23, Rule 1 of the Code of Civil Procedure, the court is not bound to allow the withdrawal. And my submission, my lord, is that there is a vested right that has been created. And my lord may ask that how and what is a vested right? My lord, I looked at judgments of the Honorable Supreme Court, and unfortunately, my lord, I could not find any decision on where vested right has been discussed at length in a matrimonial suit. However,
Yes, there are judgments.
I could not mind, my lord.
In this judgment, it has been said. The judgment which you have handed up.
No, my lord.
Please come to paragraph. Paragraph 5 of the judgment has been decided.
My lord, the definition of vested right, I'm going a little.
The definition, what is the vested right? Paragraph 5. It's well settled.
My lord, I just placed, and paragraph 5 is what I just placed before your lordship, and paragraph I am protected by paragraph.
Yes, yes, I've seen that. That is why I've said vested right has been taken into consideration in that judgment.
My lord, there is even a better definition, if I can say so. There is a better definition of vested right by the Honorable Supreme Court in a catena of judgments, and most of these, unfortunately, there may be matrimonial suits, but most of these are on.
How your right is affected? How your right is affected by this withdrawal?
My lord, let me try to understand, and I've been asking this question to myself, that what is a vested right and what is coming up amongst myriad other definitions from Black's Law Dictionary and this and that. What is coming out very categorically?
I'm fixing a date of hearing. Ashun.
My lord,
decisions which you have cited till now, all are distinguishable.
My lord,
Yes, call the next
Par-
matter.
118.
Well, at 118, I am for the petitioner, my lord. My lord, it's a suit for declaration, my lord. During the peremptory stage of hearing, my lord, I made an application for transfer of the matter. I am the plaintiff petitioner.
Transfer.
Yes, my lord. Transfer of section 24, that was rejected. Against that,
Section 24 rejected.
rejected, my lord. Against that, my lord, this application, my lord, the two grounds that I have taken in the section 24 application is that, my lord, the opposite parties are the politically influenced person, and the petitioner is not been able to conduct his case. And for this, my lord, the show cause was also given to the petitioner before he could not attend the court, my lord. That is at page 22 of the application. And my lord, another thing is that, my lord, the advocate for the defendant is a member of the is a president of the local bar association. So he is not getting a suitable advocate to conduct his case, my lord. On these grounds, my lord, I preferred the application that was rejected. Against that, my lord, this application, my lord. I have also made certain complaints before the police authorities, my lord. Evidence.
What is the stage of the suit?
My lord, peremptory hearing stage, my lord.
Peremptory hearing, the evidence has started.
Yes, my lord. I could not go to give the evidence, my lord. At page 22 is the order, my lord, where it has been, show cause has been issued to me. I could not go for evidence, my lord.
Why you could not go?
My lord, because of their threat, my lord.
Where is the evidence?
My-
What steps have you taken against those threats?
My lord, page 25 to 37, 34, my lord, the complaint I have made to the police.
25 to
25 to 34, my lord, are the complaints which I have made before the police authority.
through post.
Through post, my lord.
And what steps have been taken?
Nothing, my lord.
You have also not taken any steps against that.
That,
You are also sitting tight over the,
my lord,
and these complaint has been made only on 7th of February
yes, my
2025.
lord. Yes, my lord.
So,
That,
and the application under section 24 was filed before the,
before that, my lord.
so this is a complaint after that.
My lord, but my lord, in my complaint, my lord, I have specifically
Please
stated.
contest the suit.
My lord, I would not be able to go, my lord. My lord, I would not be able to go, my lord. So cause was issued to me. Page 21, only once, my lord. In the main suit, I was not able to go. My lord, I was restrained from going, my lord.
Yes. Where have you restrained? Where is the document that you have been restrained?
My lord, after that, my lord, I have launched complaint, and thereafter
After that, not after that. 11th of February 2024. And when you filed the application under section 24?
That was filed sometime 24 application.
So prior to that, 17th of December, and you have lodged the complaint only on February.
My lord, on February, my lord, because my lord, only once, my lord, only kindly because
Nothing. Please appear in the suit, take steps. Otherwise, it cannot be helped. This application under Article 227 of the Constitution of India
the president, my lord, our lawyer of the opposite party is the president. Kindly record, your lordship.
Opposite party is the
President of the local bar.
maybe. Yes, next.
19. Item number 119 appear for the aviator opposite party.
Aviator opposite party, yes, Mr. Banerjee.
Would it be a
And
lordship's
for partition.
on Thursday?
Yes, Mr. Bogdan.
Would it be a lordship's pleasure to take it up on Thursday?
Thursday, why?
Very frank to you, I am not in town.
You are not in town, but you are available online, Mr. Bogdan.
I don't have the brief. I don't have the brief.
Don't have the brief. Physical or soft copy?
Soft copy. Even that I don't have.
Lucky to have a brief outside.
Mr. Roy, yes.
Rejection of counterclaim. If a rejection of counterclaim by which a prayer for challenging the deed of gift has been incorporated.
Oh, so you want to, in the written statement, you want to set up a counterclaim.
Counterclaim. After filing.
By way of amendment.
By way of amendment.
Yes.
So court has rejected on the ground of limitation, saying that it is beyond limitation, which is not correct. Because, my lord, the suit was filed in lord, and I entered appearance in lord.
All right, Mr. Banerjee, you have given them copies.
Copy has been served.
All right.
So he has some difficulty as a lordship.
Heard Mr. Banerjee, learned advocate for the petitioner on the prayer of Mr. Bordon, learned senior advocate for the opposite. Mr. Bordon, learned advocate appearing for the petitioner for the opposite party. List this matter.
Thursday, Point of law, 2 minutes.
Yes, Mr. Bordon.
Point of law, 2 minutes. Thursday,
Point of law, 2 minutes. Then make your submission.
No, I'm not carrying the judgment. I am not carrying the judgment. That's the problem.
On what point you want to throw the judgment?
The counterclaim nowadays, the recent trend of Supreme Court judgments is that counterclaim by way of amendment cannot be permitted after the evidence has started being recorded.
The evidence have been.
If the evidence starts, the counterclaim cannot be permitted.
Counterclaim cannot be permitted.
In fact, 3-judge bench, 2 of them held after issues.
In the facts of that case.
Three-judge bench judgment which says it can be done.
No, 3-judge bench which says 2 of them say after.
There are 3 modes. 3 modes by which you can set up a counterclaim. Firstly, along with the written statement, then order 8 rule 9, also 5 order 6 rule 17.
Yes. Now,
that is a judgment.
Yes, absolutely, but what the recent trend? I'll come back to this. I'll come back to this. Kindly give me on Thursday, it should be Thursday.
List this matter in the 7th May. 7th May will be available. There is a long weekend thereafter.
I'll be available.
You will be there.
I'll also be there.
Behind you will not be there. Yes,
ATS, all time service, anywhere.
Please call the next matter.
Next matter.
So grateful, so grateful.
No, next matter টা হবে তারপরে.
Yes.
Outside hook. 120. Tenant filed an application under section 47. Tenant filed 47 application in execution proceedings.
Tenant filed?
47. I am the tenant. Suit for partition.
What is the number of the 47 application? No, I do not want that number. Not the misjudicial case number. Second application, third application.
I am the tenant. Partition suit filed between the brothers. Expertise allowed. Put the degree into execution. Practically by trying to evict me from the property. Whether it is permissible. Segregation of a tenancy right in the guard subject to question brother unless and
you will be tenant under the person who has.
No, one person goes to one brother. It is done with the intention to evict. That is precisely what came up for consideration without.
How are you concerned about who gets the original property?
Why?
You vacate the property.
If there is any degree against me for vacating, very
No degree passed against you.
no, it is suit for partition filed by two co-sharers.
Yes.
I am not the party. I am the tenant. I am not the party.
So why have you filed 47?
47 that degree is not executed for me against me.
No, in the partition suit.
2197, my lord. I could.
No. I could not make out. It's a suit for partition. Final degree has been passed. Allotments have been made. So the execution is for that.
For the purpose of delivery of possession.
For the purpose
In terms of final degree delivery of possession.
Yes. So your possession will be a symbolic delivery of possession so far as that you will be remaining in possession. You cannot be evicted.
Yes, police are allowed for eviction. That is precisely.
For eviction.
Yes, well, can I turn to the last but one page of the order impugned from last paragraph onwards. No.
Where is the decree?
Yes. Decree
What is the decree which they are trying to execute?
Yes. Certificate. Madam, can you turn to page 19?
Page
19 is my suit. Because I know it will come.
Your suit?
Yes, that is for declaration.
Of your tenancy right.
Right. Now, madam, their suit is for partition.
So, Mr. Rai, the partition suit is between Radha Govinda and Anup.
Yes.
Between Radha Govinda and Anup.
Radha Govinda and Kanu.
Kanu. Anup, you have filed a suit for declaration against Radha Govinda and Anup.
Biman Bihari. Biman Bihari is the predecessor.
Where do you get Biman Bihari? Please come to page 16.
Madam, can you turn to no? It is.
You have said this is your suit. So, you have Kanu Ranjan Shah. So, you have sought for declaration of your tenancy right against Radha Govinda and Anup.
Yes, Radha Govinda and Anup was one co-share. This is the other tenant.
Between
Biman Bihari and Radha Govinda.
Biman Bihari has died.
No, that is why. After that is why precisely when I to last paragraph.
No, show me the decree. Which they are trying to, which has been put into execution.
Degree copy is with me, well, just how we get it. But it is, if your lordship allows me to, I can.
So you have not read the decree also.
No. It is super partition.
Suit for partition, what is
8 share declared between the parties. Preliminary degree. And finally, precisely, that's why. What is the reason for rejecting my application? That I am not setting up an independent title. Can you turn to on going through the evidence of record? It is crystal clear.
Which page?
Last but one page of the order impugned.
Yes.
Petitioner well aware of the original title suit as the petitioners have deposed the original suit on behalf of the defendants. And I have the view that well aware of the result of the title suit. PW1 admitted that he has no right title interest or digital property, but they have interest as a possessing the digital property as a tenant under the holding. Number 30 belongs to the deceased judgment debtor, Biman Bihari Mondol. On the other hand, the OP stated that the petitioners are not tenants under the Biman Bihari Mondol. Petitioners challenging the title existing case without having good title of this suit property. I am in view. If the petitioners are the tenants of digital property, they are relieved in their own hands. I have the opinion, filing this missed case, they cannot stop the court to execute the degree which passed by this court.
What happened to your suit?
This suit dismissed, appeal pending.
What is the partition suit between whom?
Parties ke?
Radha Govinda versus Biman.
Radha Govinda versus Biman Bihari. Biman Bihari is the judgment debtor.
Radha Govinda and
Biman Bihari. From Biman Bihari is my landlord.
Biman Bihari is your landlord. He died.
He died. So here,
you have sought for declaration of a tenancy right against both.
Both.
If
your lordship wants, I can. The age-old judgment, I don't want to
What is the age-old judgment?
That this sort of partitions should be deprecated. My lord knows for the other purpose I'll say.
This matter.
108. 108. Fixed matter.
4 PM, কত নম্বর?
4 PM তো.
108. Yes, yes.
1081.
Yes.
This is, I am appearing on behalf of the petitioner, my lord, led by Mr. Ayan Banerjee in this matter. This is my affidavit of service, my lord.
My lord, I am appearing for the Srirampur municipality. I am led by Mr. Orko Kumar Nag. My lord, he is on his legs. If it can be made not to then kept tomorrow.
My lord, suit for declaration and permanent injunction, my lord, in the during pendency, during the evidence.
The municipality is the party.
The municipality claiming over my property, my lord, challenging that I have claiming over my property, my lord, their ownership over my property.
Oh, municipality is the owner of the property.
No, I am the owner of the property. They encroach my property and they enter into my property and possess the property, and they claim that there is an alleged agreement between my predecessor. For such reason, they claim property, my lord.
No, tenancy agreement. What is the tenancy agreement?
They claim, and that is the dispute, my lord. In 2020, my lord, during the evidence stage, they file an application that they want to mark a photocopy of the agreement as
Who wanted to mark?
the defendant mark, but that is the municipality wanted
Yes.
to make an application praying to mark exhibit as a photocopy of an agreement. That is rejected. That is page 28, my lord. Subsequently, in 2024, they make same application again, and that is allowed. But challenging that, we have filed this.
Where is the earlier order?
Earlier order, that is page 28, my lord. Page 25, their application. That is page 28, my lord. Later.
The certified copy of the plaintiff title suit number 14. What is that suit?
That previously my client filed a suit, my lord, but that was dismissed for default on the ground that the dismissed for, that is dismissed on the ground that the proper notice has not been served. After
What is the difficulty in marking the certified copy of the
there is no difficulty plain, but they have allowed the agreement, my lord.
So
That is,
we are not challenging with regard to the plain.
Plain, no. This is the agreement, my lord.
All right, give me a minute.
But that plaint is already their knowledge during in the evidence after closing of the
Give me a minute.
evidence. Yes.
Yes, where is the evidence with regard to this?
Evidence is not then written of
Leading of secondary evidence.
my lord, there is no evidence. Evidence for anything. There is no they have not deal no evidence has been given, my lord. As per my instruction, there is no such evidence is given.
What no such evidence? Unless the evidence has started, where is the question of producing this document as secondary evidence for marking the same as an exhibit?
Evidence
Has to be at the evidence stage.
Initial evidence stage, that evidence is not with me right now, but
Where is the any application has been filed?
yes, my lord.
That page
29, my lord, the second application. না না কিছু দেখুন এটা করছে
Second.
এখানে অ্যাপ্লিকেশনটা জিজ্ঞেস করছে জিজ্ঞেস করে টাইটেলসটা আমাদের কোনো অবজেকশন আছে
Yes, Mr. Banerjee.
Well, the first ground is that, my lord, one application was filed under section 65, which was considered by the court and rejected.
Yes.
For 65, my lord, invoking 65, he has to show the circumstances, it is in my possession, have to give a notice under 66. If in spite of notice, my lord, it is not supplied, then they can invoke 65 secondary evidence. No such notice has been given to us. Now, court has rejected, my lord, does not say on technical grounds, said I am not inclined to pass. That rejection, my lord, your lordship will find at page 28.
No, it has been said in the earlier order, page 28.
My lord.
Defendant has prayed for marking of the as an exhibit on the ground that the defendant could not file the original as it is not in their custody. That was their application.
Yes.
Now in the second application, they say that it is in your custody.
No, in the first application also same thing was said, my lord.
No, where is no?
In the first application, kindly comes to page 26, the first petition. Same ground.
The said agreement is in the custody of the plaintiffs, who are well aware. Same ground.
Same ground. In the custody of the plaintiffs. Kindly see my page 26 bottom. It is
What is the dispute in the suit?
Dispute is, my lord, property belong to my father of the plaintiffs. Now the municipality will try to encroach, saying that they are the tenant. They disclose that they are the tenant by virtue of one tenancy agreement. But the tenancy agreement,
so you have given a tenancy.
that is my father has signed a tenancy agreement. That is their claim. We said there is no such tenancy agreement. In our evidence also we have declined that. They want to bring in that document, which is not the crux of the matter. They say there's a tenancy agreement. That is not the document that could not produce, and the application to produce was rejected. They said it is in our custody. It was rejected. Second application during
was that an application for production? Where is that?
The first one is at page 20. No,
first application was for marking the photocopy as an evidence.
Agreement as exhibit.
So there was no direction. There was no notice was served.
No notice was served under 66. So they cannot invoke 65 at all without not following 66. That is my first point. Secondly, this order at page 28.
Mr. Banerjee, if an application has been filed stating that it is in your custody, let us suppose. So even then, is the notice necessary? Or in such a case, notice may not be
the
necessary.
Act statute not says so. 66 says it has to be except the circumstances stated therein. 66, there are some exceptions also.
Yes.
This case is not falling within those exceptions. This is one. And 65 also, it is not strictly. They are saying it is in my custody. That will not do. It says shown or appears to be in the possession or power of the person.
65A. They are trying to invoke 65A.
When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved. So it has to be shown to be in our possession.
Or appears to be in the possession.
Or appears to be in the possession. So it is my case throughout.
Process or of any person legally bound to produce it, and when after the notice mentioned, such person does not
produce it. Now kindly come to 66 minutes. Firstly, I say they have failed to establish or show that it is in our possession, because our case is that they are trespassers. Now 66, kindly see, my lord. Secondary evidence of the contents of the documents referred to in 65 clause A shall not be given unless the party proposing to give such secondary evidence has previously given to the party in whose possession or power the document is, or to his attorney or pleader, such notice to produce. It is produce it as it is prescribed by law, and if no notice is prescribed by law, then such notice of as the court considers reasonable under the circumstances of the case.
Proviso is not applicable.
Not applicable here. Not applicable.
So proviso is not applicable. So
now court has rejected. Now there is ground for rejection. 66 not complied. This order, my lords, now the court in the second round says that was on technical ground only, so he can maintain another application. Res judicata will not apply. That is not correct, my lord.
Yes, where is Mr. Nag? This was fixed at 4 p.m. Mr. Banerjee, you have not notified them. Already asked him to come at 4:30.
That will go up to the 5 o'clock.
Then kindly grant a short stay.
Go up to 5 o'clock.
Then kindly grant a short stay, because the arguments have been directed. Their argument complete. I have also filed my notes because I had to. So if it on 13th it is made CAV, it becomes infructuous. Short stay.
Yes. This application under Article Yes.
This matter, my lord, they have after your lordship's order. Now, after your lordship's order, my lords, they moved an application before the, just 1 second, before the learned trial court. If your lordship recalls, my lords, I had pointed out that 3 applications were disposed of.
Yes.
And the application seeking any modification in the order of visitation was not before the concerned court for consideration. Now, pursuant to your lordships heard us on 23rd April.
Yes.
Now, what they do is that on 24th April,
Yes.
Can I just pass on the order, minutes to your lordship?
April, what happened?
Now they moved an just 1 second, madam, just 1 second. You never allow the other person to begin.
Madam, he is appealing for the petitioner. Allow him to make submission.
No, there is nothing like on legs. On legs, it's not a parted matter. Now, my lord,
who is on legs?
She's saying I was on my legs on the other day. Now I have very well. Just 1 second.
Yes.
My lord, that application, just kindly take up the order. The record is put up today at the instance of the respondent who files an application stating on affidavit that an application was filed by her on 11 December 24, but the same has not been mentioned in the order sheet dated 11 December 24. The respondent has prayed for clarification and or modification of the order dated 11 December. Copy is not served, so we don't have any idea. But nature of the application is such that notice of today's application upon the petitioner is not required. Perused the record and found that an application was filed by the respondent praying for modification of the visitation order internally on the ground of inconvenience of the child. There is no endorsement on the application dated 11 December that copy of said application was served on petitioner. So I was right, my lord, we have not got a copy. The order sheet dated so and so of this court does not reflect filing of the said application. On 11 December, an application dated 3rd December was filed by one Rajkishore Soni was heard.
Your application.
No, this was not my application, a third party, a witness. On perusal of the entries dated so and so and the court fees registered is found that the court fees filed in the application by the respondent has been entered. Accordingly, the application filed by respondent today by way of put up is disposed of. So it makes very clear that their application was never being considered by the court. They have not served. Even this application for modification is not served on us. It is being taken up and decided. Not very unfair procedure is being followed with great respect. Yes.
Which reply? This opposition you have filed.
I have received a reply. No, we can argue and dispose it of in 5 minutes. I will show the order is purely without jurisdiction. So just 1 second. And what this is not the first time that it is.
The application you had said whether you had filed it or not. Secondly, my lord had said, considering the welfare of the child, whether in May, that is the month of May, which is the upcoming visitation of the father is 10th and 11th. We said he can come to Delhi. What is the examination schedule of the child? My lord had asked me this. Right? So I have filed a detailed reply. I have given him a copy so that these two things are brought on record with the school schedule. The mail from the school of the exam, which starts from the 15th, 27th. And my lord, there is a summer vacation starting from 2nd.
No, we come on all that, those issues very well.
Let me speak.
Very well.
Please sit. So on 28 days in June, that is the summer holidays in Delhi as well. 28 days, my lord, the child is with the father, grandparents, etc. So now we are only considered with me. In April, his visitation couldn't attend the father because he said that it was president. I don't see how, but anyway, he did come. Child was waiting ready at 10. Now the father had visitation on 10th and 11th of May, second Saturday.
10th and 11th of May.
Every second Saturday and Sunday, the father has the child. So we are saying fine. We are okay with that. Now, my lord, then in June again for 28 days, the child is with the father, grandfather, Calcutta basically. She has requested the father, please take me for a had a conversation yesterday after it. So he can go with her either for a holiday or stay with that's 61. We have said rented a house, but I never wanted it. Does the child stay? So we have no problem with it. My only request is this matter, my lord, just think. 19 should have been. Last, I've got the orders, last 3 opinions, it's just given. Once it's identified, that once he got the money for cross-examination, he was asked to pay it. Now, my lord, humble request. What will dragging the child in May serve? Now, my lord, I want to show something which is very important, my lord. We'll just see, kindly, sir. My lord, in fact, my lord, may kindly see this. I have judgments also. My lord, I have given the exact exam schedule. No. My lord, I have to help you. I have given the index. My lord, sees page 83. I have given this.
All right, let me hear the petitioner.
Now, my lord.
Madam, will you please allow the petitioner to make his submission? I will come back to you. Yes.
Now, my lord, the impugned order.
Please take your seat.
The impugned order doesn't touch upon the summer vacation or any other thing. My only grievance was that visitation at Calcutta was going on every alternate month. It has been stopped or modified, whichever way you look at it, by an order where it was my application being considered for terminating the lease deed. That's all. Now, my learned friend vehemently said, no, there was an application, it was being considered, etc. They filed an application. Now, the order is very clear. So, neither we are served with that application. Now, something very interesting I'd like to show from their reply. Whereas the learned judge says, kindly just take their objections. What are they trying to do? Because this is not the first time I'm seeing all this happening in this case. Just kindly come to page 13, 1-3.
Yes.
Annexure A, they have placed on record.
Yes.
Now, my lords, in Annexure A, what they are trying to show to your Lordship's court is that their application of 11 December 24 was served on the advocate on record before the learned trial court. Lordship has Annexure A. Now, my lord, with great respect, first of all, that index that your Lordship has mentions an application dated 11 December 25. There is no mention of 11 December. Just once.
Not even this.
Madam, if both of you start arguing at the same time, it's very difficult. Please take your notes. You will be having your chance of reply. Please don't interrupt. That's not the practice which is being followed
by this court. Now, my lords, your Lordship would see here they are mentioning 11 December 25, which is yet to come. Yet to come. We are still in May. Here they are showing you a purported receipt under the signature of the advocate on record for the petitioner of 11 December 24.
Now, typographical mistake.
No, I'm saying something more. The learned trial court on their application says, admittedly, nothing is served on us. Then how, my lord, this Annexure A can be filed? Why I am saying this is, it's not a new thing that is happening. Just kindly now come to page 295 of my paper book. How the process starts and how this always hoodwinking the Honorable Court on some pretext or the other. 295, the first attempt.
Yes.
Lord, because they can go to any extent. Just see, this is an order, my lord, passed by my lord Justice Shampa Sarkar. And paragraph 2 at page, I'm sorry, not 295, 339. I'm so sorry. 339.
Yes.
The Lordship has it. This is an order of 27 February 2020.
There are 2 page numbers.
Yes,
one on the right hand side.
Please follow the center number, not just our mistake. We are troubling your Lordship. 339. That's an order of 27 February 2020, my lord. Your Lordship has it.
Yes.
Please come to my lord's paragraph 2 of that order. It is necessary to put on record that the petitioner Deepika Agarwal had sent messages to this court on WhatsApp, which would be a ploy to ensure recusal. It's an usual practice for bench hunting. Although no such direct request was made, the fact that the petitioner collected the personal number of the court and sent some messages was an indirect way of seeing recusal. Fortunately, my lords, the learned judge doesn't recuse and continues the hearing. Now, my lord, the matter goes to an extent where repeated instances of contempt in disobeying all orders are culminated, my lord, at page 357. Just kindly come to 357.
Yes.
This is, my lords, in contempt proceedings, the final order. At page 364, Lordship may kindly mark paragraph 9, last 3 lines of paragraph 9. That makes a mention
of what they tried to do, my lords, to obtain recusal.
Paragraph 9.
Paragraph 9, last 3 lines of that paragraph.
Yes.
Because successive acts, my lords, culminated in holding contempt against them. Then, my lord, please come to page 365. The alleged paragraph 12, my lords, I am reading. The alleged contemptor further disclosed that she got the child admitted at Lancers International School, IB School in Gurgaon, and there was no requirement to mention the name of the father in the admission form, which is why Rishi Agarwal was not introduced to the school authority as the father of the child. It is contended by the alleged contemptor in an opposition that in consonance with the direction so-and-so, she brought the child on every third weekend in spite of protest by the child and her unwillingness to come to Kolkata. The flat at which visitation took place, 3 male servants were engaged who clicked her photos, etc. From the facts and circumstances of the case, paragraph 13, my lords, as stated herein above, it appears that the alleged contemptor Deepika Agarwal has been evading the direction of the courts given to her from time to time. Earlier, she made an attempt to establish contact with the Honorable Judge adjudicating a civil revisional application being CO 622 of 2019 to obtain an order of recusal, as observed by the Honorable Presiding Judge who was in session of the matter. On 20th June, this court, in exercise of parents' patriarch jurisdiction, interacted with the child on the 4th and 5th of July 2023, and the child was produced before the expert of Institute of Exceptional Children, Mumbai, and the expert observed that the child experienced feeling nervous and fearful when she was questioned by authority. While interacting with Sambhuti, the child, on 20th June 23, this court found her quite comfortable, composed, as it was recorded in the order of 20th June. The report of Institute of Exceptional Children indicates 2 possibilities. It is tailor-made to create a pressure upon this court, again a second attempt, to recuse as was done with the learned coordinate bench by sending WhatsApp message, or the child was taken to someone stranger to her for some purpose best known to the mother. Then, please come to paragraph 18 on the same page, foot of the page. The conduct of the alleged contemptor unerringly indicates that she has developed a mechanism within herself to be in conflict with the order of the court. Her conduct is eloquent about her disrespect towards the rule of law, her lack of faith in truth. Law is a command sovereign and it cannot be afforded to be violated again and again for the interest of civilization. When a person makes it a point to evade or defy the command of law, it becomes inevitable to confront with such situation with heavy hand in order to uphold the majesty of law. Then, my lords, when this was going on at page 368, then they come with an apology. Now, paragraph 22, your lordships deal with apology. The apology so tendered by the alleged contemptor is not a good grace apology. It is bereft of remorse, regret, or repentance. It is tendered to avoid the rigor of law. Srimati so-and-so, the alleged contemptor, is found to have been making deliberately and willfully wrong statements to mislead the court. She is always in conflict with the order of the court. She has been evading every direction of the court and thereby willfully violating the order of the court. Thus, there is every reason to hold her in contempt. Now, paragraph 24, keeping in mind, my lord, that the child is with her, your lordships don't send her to prison but ask her to submit an undertaking. Now, that undertaking, my lords, has got 5 paragraphs that she is to abide by every direction that is passed by the court. However, keeping in mind the paramount consideration before the court is the welfare of the child in order to avoid any situation that may emotionally disturb the child, I am inclined to give the contemptor an opportunity to purge herself. So, henceforth, Srimati Deepika Agarwal shall never be in conflict with the order of the court willfully, or shall not make any attempt to defy or evade the direction of the court under any circumstances, unless she feels aggrieved by such order and decides to challenge the same following due process of law. She shall inform the authority of Lancers International about the father of Sambhuti Agarwal. She shall introduce Rishi Agarwal to the school authority as the father of the ward and request the school authority to inform the father to attend parent-teacher meeting and other meetings in the school in future. Now, this has happened only about a couple of weeks back, not before that. She will not take any decision unilaterally that touches the life of the child Sambhuti, be it her education or health issue. She will inform Rishi as to why Sambhuti Agarwal had to be taken to the Institute of Exceptional Children in Mumbai, not informed. If necessary, Rishi Agarwal shall be allowed to accompany the child before the experts. She shall share and shoulder the responsibility in raising the child jointly with the father. She shall not take any decision touching upon the life of the child without having any consultation with Rishi, unless there be any compelling circumstances. She shall accord Rishi Agarwal the dignity and shall refrain from behaving in such a manner that may lower down the dignity and prestige of Rishi in the estimation of the child. This is equally applicable to the petitioner. She shall obey the order of the court in letter and spirit unless such order direction is challenged before any forum. So this happens, my lords, in contempt jurisdiction.
Yes.
After this, even at the stage of filing of an undertaking in respect of this order, please see the utter chaos they created. That is 372. Next order. Annexure C at page 372.
Yes.
May I read, my lord? Pursuant to the order dated 4th October 23, the contemptor Deepika was supposed to file the undertaking by 9th October, but it is filed today, having affirmed on 10th October 23. In paragraph 9 of the undertaking, it is written that the contemptor received the copy of the order on 9th October 23. It is submitted by Ms. Mitra under the instruction of AOR Mr. Paul that the order was uploaded on 9th October 23. Refuting such contention, so-and-so submits that the order was downloaded by the petitioner on 5th October 23 itself. Belated filing of the undertaking is nothing but manifestation of the defying attitude of the contemptor. Mr. Paul Learned so-and-so maintains his stance that the order was not uploaded on 5th October 23. Now look at how court goes. However, report in this regard is attained from the office of the learned registrar listing, which indicates that the submission of the learned AOR is factually incorrect. Then, my lords, again, the court accepts it that very well, let it go belatedly, but then says that it's unfortunate to see the role played by the advocate concerned, etc., etc. And this is how the undertaking comes on record.
Yes.
Then, my lords, is the order, final order passed at page 375 by this honorable court, my lords, fixing that detailed visitation will take, how visitation will take place, how summer vacation will take place. That is an order of 24th May 2024, page 375.
Yes.
And my lord, those directions are there. I needn't reiterate them, except that your lordship would find those directions at page 409 to, my lords, 414. So it says, my lords, one month the child will come, 1 month the father will go. And it was working fine. Now, my lords, the question was, we came up before the Honorable High Court, my lords, at page 427, moving an application that please allow the child to come and stay at the residence of the father. That was, my lords, 427 is Can 6 of 2025. On the ground that when the child comes to Calcutta, shifting two houses, my lords, is not the correct way. As it is, she is coming from Delhi. Let it be, my lords, that she can be residing with the father. Now, that application, my lords, is disposed of by an order passed at page 436, 17 January.
Yes.
Which says, my lord, that whatever prayer you want to make, you can make before the learned trial court. That is page 437, penultimate paragraph. Petitioner is granted liberty to make necessary prayer with regard to the developments before the learned trial court, and the learned trial court shall decide the same in accordance with law without in any manner being influenced by this order. It is in this context, my lords, that your lordship would find is my application at page 438 with prayer at page 443, which your lordship had seen on that day, which only deals with, my lords, permitting me to terminate the lease deed.
Yes.
Now, there are two other applications, my lords, which are filed subsequently. One is at page 453 and the other is at page 461. 453 is a very unfortunate incident which takes place at Delhi, where, my lords, in presence of the child, the father is abused, the father-in-law is abused, etc., etc. That is all on pen drive and now admitted before the learned trial court. And 461 is an application of how the child was brought to court, my lords, for the purposes of meeting the learned judge and what transpired. Now, my lord, please take that application. It is at 461.
Yes.
Paragraph 3, that certain developments took place, 462, my lords, I am reading. Paragraph 3, that certain developments took place in the matter on 24 January when the petitioner got information that the child was unwell and down with fever and consequently could not even attend school on 24 January. The events which transpired on 24 January when the petitioner visited his child have been narrated by way of a separate application filed before this honorable court at 10:30 a.m. on 27 January. Along with the said application, a pen drive containing the audio conversation between the respondent, the child, and petitioner has been filed. The respondent can be heard abusing the petitioner with the choices of abuses and also abusing the grandfather of the child and calling him a thief and rapist. This honorable court, upon receiving the application, permitted the consul to serve the application. Application was served via email, etc. Proof filed. Now, my lord, that by way of the present application, the petitioner wishes to place on record some very serious, shocking and disturbing turn of events which took place in the courtroom on 27 January between 2:45 to 3:15. The petitioner reached the court premises around 2:30 and waited for his counsel. At about 2:50, the petitioner entered the courtroom after arrival of his counsel and saw the child was sitting on the penultimate sitting bench on the extreme right side of the courtroom. As a father, the petitioner got emotional, also because of the fact that respondent was nowhere to be seen in the courtroom. The child was unwell on 24th January and had about 101 fever on the said date, and petitioner naturally wanted to talk to the child. While he just began interacting with the child, Miss So-and-so advocate, who is not the advocate on record, very rudely told the petitioner he should not interact with the child. Petitioner was not duty bound to follow any dictates or instructions, since there is no direction by any court that petitioner cannot interact with his daughter. When the petitioner persisted interacting with the daughter, so-and-so sternly told the child not to interact with the petitioner. The child was responding to the interaction with the petitioner, at which moment so-and-so got up from the front row sitting bench and pulled the child to the front row and made her sit between herself and another advocate to prevent any interaction with the petitioner. The child obviously got upset by seeing all this. Even when the child was sitting on the front bench between so-and-so and so-and-so, was continuously interfering with the conversation which the petitioner wanted to have with his daughter. Frustrated, the petitioner came back and stood beside the almirah adjacent to the last sitting bench, and the Honorable Court also called the child in chamber at that point of time. After a few minutes, when the child came out of the chamber, so-and-so literally snatched her from near the witness podium on the right side of the courtroom, and while pulling the hand of the child, causing extreme pain and anguish to the child, ran out of the courtroom without even waiting for the Honorable Judge to assemble, and without even showing the necessary decorum to receive copy of the application moved on behalf of the petitioner in the morning. The manner in which the child was pulled by so-and-so was seen by everyone sitting in the courtroom, including the court officers who were witness to the manner in which child was taken away from the courtroom. In fact, one of the court staff said that manner in which the child could be pulled by hand could easily dislocate the hand. Now, all these things are on record. No denial by them. They have not chosen to file any replies to any of the three applications. Consequently, the impugned order which your lordships are holding also disposes of two applications apart from my application seeking termination of lease, and virtually admonishes the concerned advocate that such conduct should not happen in court. Now, my lords, it is in this manner that the child met the learned judge in chamber on this day for a very brief, my lords, hardly 2 to 3 minutes or maybe even 4 minutes. And on that basis, that took place on 27 January without any formal application on record. Nothing is put on record in the order of 27 January what has transpired in chamber. Then, my lord, 20th March, 2 months later, is the order impugned that is passed, that on the basis of my interaction on 27 January, I am stopping visitation at Kolkata, my lords. Please take the impugned order now. It talks of the interaction, my lords, of 27 January.
Yes, anything more?
No, this is, my lord, covers everything, my lords. So I am respectfully praying, my lords.
So you have 2 points. One is that no application for modification was filed by them. And on the basis of the personal interaction of the learned judge with the child, on 27th, this order was passed.
Yes.
Anything
more?
more?
On 20th March, this order has been passed.
Anything more?
No, and therefore, my lord, since they have filed a reply, either lordships can dispose it of, my lords,
yes,
by setting aside the
now let
order.
me
Yes,
hear.
please, please. I'm so
Yes.
grateful, my lord. Deeply
Yes.
obliged to my.
Yes.
It's an interim order.
কাজ করছে না ওটা শোনা যাচ্ছে না
Is it okay, my lord?
Yes, yes.
This is the third time they are coming against the interim order. The first time when they came, because of COVID and all, it was all delayed. And finally, Honorable Justice Roy Chaudhary passed an order. All the contempt and all that he was talking about was just a short period. There was a puja which was child was supposed to attend. Father went to pick up the child, sat for 4 hours. Child had a very bad toothache, did not go. They filed a contempt against the mother. Anyway, forget that. It's all done and dusted. Twice over, the cases have come up. Finally, my lord, Honorable Justice Vishwarup Roy Chaudhary passed an order by which what was their petition? They had gone against the interim custody granted to me. So finally, they said that let the lower court decide. At that stage in 23-24, my lord thought that this matter is ripe, it should be heard. There was also a Supreme Court direction, all these matters in 6 months should be finished. Unfortunately, continuous adjournments were taken. Every time he would get up for evidence of the mother, he got both the matrimonial and the custody case fixed together. Interim custody was with me. The child, every alternate month, my lord, stays in Safdarjung Enclave in Delhi, goes to an international school. He would send tickets for the child. Late night on Sunday, she would reach. Half the time, she couldn't attend on Monday. Again, she was tired. So she kept insisting with me, my lord, that please let me meet the judge. Why can't I not have to go? Why can't my papa come to meet? She had 2 grouses, my lord, which she shared with the honorable judge. Her first grouse was, I get very tired. Saturday early morning, 6 o'clock or 7:30 is the flight, as my lord knows, going to the airport. Sunday late night, I come back. Sometimes the flights are delayed. It's in nobody's hands. Next day early morning, 7 o'clock, my school, I have to leave. So I get very tired. Why can't Papa come to see me? He can come more than once a month. We can go to a mall, this, that. Her second grouse was, when I go to Calcutta, I don't get to see Papa that much. I'm in a flat, separate flat. My grandmother comes, this Papa is busy, which I understand. He's a very big businessman. He has factories in Vietnam, Nigeria, and Bengal, etc. So he may be busy. This was her point. Now, my lord, I moved an application on 11/12/24 when the matter was coming up in December. I moved an application before the Honorable Lady Judge. It is, my lord, see in my reply, their advocate on record acknowledged it. Unfortunately, my lord, and that is my mistake, when the order was being passed, because this came much later in March, immediately on my application, the Honorable Judge passed a speaking order saying that the child can come when is her next visitation. She did not want to inconvenience the child by coming twice. Excuse me. So she said, when is the child's next visitation? This was in January. December, the matter came up. So I said the child's next visitation, because this month the father has come, the winter holidays. It is on 25th, 26th of January. So my lady said that 27th, I will meet the child. Then she does not have to come twice. This was the thing. They did not oppose. On 24th, my lord, which was a Friday, because the child comes over the weekend. In the morning, the child had a slight fever. So the mother, she always, after her undertaking, she always keeps the father informed about the child not going to school on a particular day, going for camp, parent-teacher meeting. He never attends, but she informs him. And she has told the school he should be, if he comes, he can attend. Now, my lord, on 24th, when the evening, because the mother was packing, she saw certain things for the child she needed to buy. She went down to the South Ex market. Suddenly, the father turns up in the house. His child is supposed to travel on Saturday morning to Kolkata. He has sent tickets. Mother is packing. And starts, what has happened, what has happened. The mother got very flustered and all. And my lord, he goes back and he cancels the ticket of the child. Why does he do it? Because the child has to come to Kolkata. He knows the child has to meet the honorable judge. Now, my lord, he said an application against the lawyer. Anyway, what happened on the 27th is, they were not supposed to be in court. Only the judge had said, I will meet the child. Anyway, all of them came, including the father. The child was sitting quietly at the back. Between 3 to 3:30 p.m., the honorable judge, not 2-3 minutes as he said, I'm sure your lordship understands that a lady judge, responsible judge, will not call a child all the way from Delhi and meet for 2 to 3 minutes. 3 o'clock to 3:30, she met. Before that, I was present in the court. My learned junior was present. The child was sitting between us. My lord, he came like this. As you know, Alipur court has very, very small rooms. He came, and in our presence, he's telling her, today is D-Day. If you say you will not come to Calcutta, things will happen. He was literally threatening her. Anyway, the judge met. I told her, just be quiet. She's a small child. And frankly, my lord, parents are fighting. They are very rich. They are fighting. The matter has gone to Supreme Court, 3 times to High Court. Poor child, she should not be traumatized, my lord. She is now 12 years old. She has her studies. She's a very exceptionally bright child. It's been noted by the honorable judge who has met her, both in the High Court as well as here. Now, my lord, if you see, I do these matters on a daily basis, Supreme Court and here. My lord, now the judges are the judgments of the Supreme Court are very clear. They say, my lord, may kindly see this, sir. I have the judgments also. I'll hand them over. My lord may read them at your leisure. Here, sir. Sir. This Sugrita's judgment, my lord, in fact, in this Honorable Justice Vikram Nath's thing. If I may just read one para. This was a case, my lord. Should I just say it or you want to?
Yes, yes.
So, my lord, this was a similar case. There were a pair.
Which judgment you are?
My lord, the first one.
Sugrita.
Sugrita Gautam.
Yes, yes, I've got that. Yes.
Yes.
I've got that.
Yes. Do you want the copy of the Supreme Court?
You have given the copy of this.
Yes. So, Sugrita versus Gautam, 20th December. It's a latest judgment, my lord. It's just got reported.
Yes.
The husband and wife were doctors. They had a similar matrimonial dispute, my lord. The wife was staying in a place called Madurai, and the husband was staying in a place called Karur, which is 300 kilometers away. They were both government doctors. Now, my lord, the same issue arose whether the father will travel from Karur to Madurai to meet the child, or the child every alternate month has to be brought to from Madurai to Karur. My lordship may just see para 14.
Yes.
Para 15. Can I just read, madam?
Yes, yes.
In all of this, that is, they've given the entire dispute, the interest of the minor child is paramount. In the process of adjudication upon the rights of the parents, her health means the child. Health cannot be compromised. Further, while the respondent has a right to visit the child, that is the father, it cannot be at the cost of the child's health and well-being. Keeping in mind the best interest of the child and the interest of the parents, we agree with the High Court to the extent of granting certain visitation rights to the respondents. But the direction set up to enable to be adversarial. That is, the child will travel from Madurai to Karur.
Yes.
Next para. The directions passed by the High Court as well as the Family Court are not supported by any cogent reason for allowing the visitation to take place at Karur. These orders do not provide any justified reason and do not appear to have kept in mind the best interest and welfare of the child as paramount. Thus, keeping the interest and well-being of the child as priority, we deem it appropriate to move the place of visitation from Karur to Madurai.
Yes.
Now, my lord, there's a case, another case of Supreme Court. Dipti Bhandari, in fact, I had done part of this matter, my lord, which is exactly the same facts as this case, my lord, but flipped. So the mother shifted to her parents' house in Kolkata and Papa was in Delhi. Has my lord got that?
Yes, yes.
Dipti Bhandari, should I give a copy of the judgment?
Yes, yes, you have to give. Paragraph 14 of the judgment.
Yes, my lord.
Yes.
Obliged. Paragraph 14, my lord, they say, it is true that the transfer of several cases to Delhi, that was also a TP, my lord, that was being adjudicated, is likely to cause some inconvenience to the respondent father and his family members. But it cannot be denied that it would be easier for the respondent one mother to attend the proceedings in Delhi and that the petitioner to attend the same in Jaipur. So here, my lord, it was a case of Delhi and Jaipur, while staying in Delhi with the minor child. Now, my lord, just I'll stop here for a minute because I had been partly part of this, my lord, Dipti's case. It was very, very similar. They had a domestic violence issue, my lord, and she from Jaipur, though her father and brother and all were in Jaipur, similar to this Deepika's case, she had moved to Delhi with her brother. Her brother had got an admission in ISBM. The parents had taken a flat and she was staying with the child. It is undoubtedly true, my lord, that the IB schools in Delhi are better than, say, Jaipur or whatever. Now, here the case was, as you know, Jaipur, Delhi is 250 kilometers, my lord. It was again held that in the interest of the child, the petitioner can have no objection whatsoever so that he goes to meet the child.
Yes.
This are, my lord, two Supreme Court cases, my lord.
Yes.
I'm not going into the transfer petition. Now, my lord, look at this case. I have tried several occasions, my lord, so that they mediate and they settle their dispute. Okay. Now, whatever is the case, maybe too much ego, too much money, and I will say it on both sides, my lord. I've been personally doing this case. I do these cases on a regular basis. The middle class young couples these days, they go for a mutual divorce. It's a costly affair, my lord. They've gone to Supreme Court twice. This is the third time they're coming against interim stage, my lord, still lower court. There is all kind of cases going on. I'm not even getting into the false statements. My lord knows it's par for the course. The father who's a billionaire, show me that article, whose name comes in all Business Today and all. I have affidavits, my lord, before the lower court. Kindly show this.
For what?
Saying that he earns 25,000 rupees a month. All these
You're
things
not
go on.
concerned with this.
Now, my lord, the only consideration, because this child, she's literally, now she's in her 12th. I have given my lord in my reply her whole exam schedule. I've even attached the school calendar and all that. There is no dispute. My lord, also what surprises me, the father has access to the school portal. We have shared passwords with him and everything. Okay, he doesn't come for parent-teacher meeting, but I have recorded conversations. He talks to the child once a week. He talks sometimes twice a week. The child has been telling him, Papa, may I have exams? When are you coming? Are you coming for sure? Because she was very disappointed last time he didn't show up. He knows she has exams, right? He knows that 15 to 27, these are her final exams. Then she goes to class 7 in the IB school. Now, my lord, in spite of that, she knows that she gets very tired. There have been occasions the flight is delayed. He knows. So I feel, other than a legal point of view, from a father's point of view, of course, the honorable judge is the father really in these cases. And at every stage, the Supreme Court, the Honorable High Court, even lower courts, they say, forget the parents, what they are fighting, that we'll see. Look at the welfare of the child, my lord. That's all, my lord.
Anything more?
No, my lord. And I have filed
anything in reply?
Yes, my lord, I have filed my reply in which I have not only filed my application, in that there's a clear prayer for the judge to meet the child, which is why she met, and I've given the exam schedule you want. Oblige, my lord.
I'll take only 5 minutes because, my lord, we are way past your lordship's rising time. Just kindly take the order, my lords, of which was passed in contempt, which I was reading at 357. And please come to page 359. How an interaction is taken place with the child and how it is, my lords, to be dealt with by a learned judge. 359.
Not on facts, only on the legal point, the decisions, if you want to submit anything.
Just for 2 minutes on facts and then I quickly, decisions I'll point out from this only.
259.
359, Lord.
Yes.
Begins at 357, 359.
Yes.
Now, Lord, when the contempt proceedings were on, your lordship can call the child at any point of time. Absolutely no dispute about that. Now, please see last line at 359. Accordingly, I directed the parties to bring the child to my chamber from 3 p.m. till 4:30 p.m. I interacted with the child. During my interaction, I find her to be an intelligent and smart child who can articulate her thoughts and ideas well. She is very clear about what she wants and why. At the outset, the child informs that though there is discussion about holidaying for some days, nothing has been decided. The child tells that she is tired of the tussle. She wants her father to come to Delhi in every alternate month. Kindly market this at my request. He will be staying in a hotel. She can spend a couple of hours with her father in the said hotel for 2 days. In the next month, she will fly to Kolkata and spend a weekend with her father. The rest of the time, she and her father can get connected once a week virtually. The child wants both the parents to spend equal time and wants the parents to have patience, etc. And then it goes on. So, my lord, this arrangement that was brought about initially, the learned judge interacted with the child, and this, my lords, is an order passed only in October 2023. So it's not as if, my lord, that it is a long time back that this order has been passed. Sorry, 2023.
Yes.
Then, my lords, is my learned friend has not dealt with any of my contentions on the point that an order passed by this honorable court cannot be modified in my respectful submission by any court without a formal application and without notice to me. So that part she is carefully, my lords, avoided to answer. Now please come to the impugned order, and I'll show to your lordship, my lords, how the impugned order has been passed. Order number 88. May I read, my lords? The record is taken up for passing order in connection with the 3 applications filed by the petitioner father on 22nd January 25, 27 January and 28 January. I have heard the learned advocates for both the parties at length on the previous date. Respondent mother did not put in any written objection against any of the 3 applications. So this is one point, no objections. The first application has been filed with a prayer permitting the petitioner to terminate the lease deed for property bearing number so-and-so and allow the child to stay at the residence of the petitioner and the grandparents as so-and-so Circular Road during visitation. It is contended on behalf of the petitioner that the flat taken on rent at 25 so-and-so is used only for 2 days every alternate month during visitation. And if the court permits, it's not my view, I'm asking a permission. If the court permits the child to stay with the petitioner and his parents, that is the paternal grandparents, it would spare the petitioner an excess burden of 76,000 which he has to incur as rent. The petitioner has also added that the petitioner has paid all arrears, arrear maintenance amount of 19 lakhs and continues to pay 50,000 per month as per order of the domestic violence. The learned advocate for the respondent, while yielding to the prayer for termination of the lease deed, has submitted that visitation in Kolkata be stopped altogether as it is causing a great deal of hardship for the child. So this is only purely an oral submission, my lords. In reply, the learned advocate for the petitioner submitted that it is necessary that the child meets her grandparents, and the Honorable High Court in the order dated so-and-so was pleased to direct to take the child to the house where the petitioner is residing with the parents for a period of 3 days. In CO number so-and-so, Honorable High Court directed liberty to the parties to approach the court for so-and-so. Then, my lord, comes the important part. On 27 January 25, I had privately talked to the child and she has revealed to me that visitation in Kolkata is becoming difficult for her because she has to miss school on each occasion as she has to come down to Kolkata for visitation. Considered child is in class 6 now, etc., etc., and then she stops visitation. She stops visitation at Kolkata. Then what the rest of the order for the other 2 applications that I'm not troubling your lordships presently. Those will be subject matter, my lords, of different proceedings. But then she says, ordered the child shall no longer be required to come for visitation to Kolkata. The petitioner is directed to meet the child every month in New Delhi on 2nd Saturday. I was already doing that, except the last time in March, when this impugned order was in the face of us to come before this honorable court, he did not visit. Apart from that, he has been going to Delhi and she was coming to Kolkata. It was all fine. I could have understood, my lords, if on 27 January 25, when the learned judge met the child, she would have accounted for it, my lords, in the order, so that at least we would have noticed to what first fallen from the child. Point 1. Point 2, my lord, there is no application from their side for modification. Point 3, my lords, if there is no application, simply on the oral submission saying that the child is feeling inconvenience is completely contrary to what the child has said before my Lord Justice Siddharth Roy Chaudhary in chamber in a discussion of nearly about 2 hours, where she says, no, I want my father to come every alternate month and I also want to visit Kolkata. Now, this sudden change of events, my lords, when the custody petition is at the virtual end, which has disturbed the entire scenario. Now, my learned friend said that we have been taking adjournments. Now, I have brought, my lords, all the orders for your lordship.
This is the stage of hearing of the custody application.
Yes. So, my lord, what has happened is, first of all, she delayed filing her affidavit of evidence. She wanted that the divorce case should go separately, custody case.
Now, what is this?
Now she is under cross-examination.
My lord,
Now, just 1 second.
Of adjournment.
He is under cross-examination.
You are cross-examining her.
We are cross-examining her.
Yes.
We have already cross-examined her at length on one particular day.
Yes.
Then, my lord, she also has to catch a flight to Delhi. I also have to catch a flight. So the learned court is very, my lords, I would say, benevolent to accommodate both of us. Then what has happened is, my lord, that she will start crying in court for about 10-15 minutes. You require time to console her. The court will take some time to console her. Water is given to her, etc. Then I begin my cross-examination, asking some questions. She flatly denies everything in cross-examination. So necessarily, my lord, to protect my client's interest, I have to confront it with the documents. It's not as if, my lord, that I am cross-examining her on something which is oblivious to the main petition. So she is under cross-examination. Finally, my lord, the learned judge is now not holding court. I am told she'll get transferred.
She's already transferred, my lord.
You have more information, but I don't have that information. So she's getting some transfer. So a new judge is likely to come. Those proceedings are fixed for 13th of May. So the new judge will come, my lord. He will take some time to get apprised with the record. We'll have to tell him the history of the litigation. So cross-examination, my lord, I would feel should get completed by the end of July. At the most, my lords, by August. And the matter can be heard for final hearing. Now, I was saying that is what exactly.
Your evidence is completed.
My evidence in custody case is completed. My evidence in yes, divorce case is also completed.
So only you have to you have to complete the cross-examination.
Cross-examination of this lady. For that, it is 13th May. I don't think it is likely to be taken up on 13th May because the new judge who comes will take some time to arrange his board and understand the nuances of this case. The trial court brief itself is running into some 500-700 pages. I am only requesting, and I requested the learned judge, please don't disturb what is already taking place. It is going on smoothly. Now, the judgments which she is relying upon, I have gone through the judgment of my Lord Justice Vikram Nath. Please take, that is a case of a 2-year-old child. Now, just kindly come, my lords, to.
Which one, Sugrita?
Yes, you relied on Sugrita. Come to paragraph, my lords, 8 of that judgment, please. Sugrita versus Gautam.
Yes.
This court, while issuing notice, had noted the limited grievance raised by the appellant in the present appeal is that while passing the impugned order, the division bench of the High Court did not take into consideration the fact that venue for the respondent to have access of the 2-year-old minor child of the parties is 150. Now, my 2-year-old minor child certainly may not will face difficulties.
Yes.
She is a 12-year-old child. A. B, my lords, I think, subject to correction, the tickets, my lords, are either in business class or premium economy, both ways are arranged. The mother stays, my lords, in some 5-star hotel. The daughter comes and stays here, my lords, in the best of properties that are maintained by the father. Then what, she doesn't feel that inconvenience. In fact, if your lordship would see the record which is placed, all the Honorable High Court judges have directed me, please maintain a tuition teacher, please maintain a computer for her at home, so that while visitation also, her my lord, schedule is not disturbed. I maintained each and everything to the best of my ability. And it is only at the fag end I said, just allow me to terminate that lease deed, because now the Honorable High Court has permitted that the child can stay with my parents. Earlier they had an objection, but that objection has now been sidelined by the Honorable Court. So now that I can bring her there for 3 days, why should I keep her for 3 days there and 3 days in another property? So she'll come bag and baggage first to a rented property, then she go back to my parents' house, then we again shift her back to Delhi. So instead of 2 houses, let her stay at 1 house. That is all. That was my simple prayer. How can, my lord, then, considering that prayer, the court modify the visitation? But that is my respectful submission.
My lord, if I may.
And but so far as grandparents are concerned, my Lord Justice Bishrup Chaudhary, while passing the final order, said meeting the grandparents and the who has a very, very important facet for the child's development, no matter whatever be your allegations against them.
All right.
Deeply obliged to my Lord.
My lord, just one last thing, please. When the visitation happened on the 27th, because after all, why did I request in my application for child to meet the judge?
There is no such application.
She kept, my lord, I filed.
There is no such application. There is no such application, my lord.
May kindly just see this. The
order is clear.
My lord, the child, after the visitation got over, that is on the 27th,
I sent you an email.
On 29th, she said, thank you for the nice lunch and making me meet the judge personally. She was a very kind lady and listened to me and my problems of coming to Kolkata every alternate month. I do not want to come Kolkata in the weekend because my school gets affected. She understood. Thank you for the
support. Truth, you don't require all these emails
now,
at all.
my lord, so ultimately, it's the child, my lord.
All right.
They are fighting the child. And my lord, all of
the
us.
advocates. Opposing grandparents visitation at Delhi.
I have instructions from my client. This is the same question I told her because
You do not have any
my lord,
you
we
do
have no problem if the father, the grandmother, but the father should also come, my lord.
Now the father-in-law,
father, father-in-law, mother-in-law, and the bua.
For the first time.
If now they are saying that they do not have any objection.
Delhi, if it is Delhi, the child will not travel.
If it is Delhi, they will certainly go. They will certainly go. The father is going, they can also accompany.
Yes.
But not
only request
just
the
one
child
second,
has
madam, just 1 second.
She gets a silent little one
last time,
with the child.
Lord, it is very unfair on my learned friend's part. Last time they went, my lords, to Delhi. My client, that is the father, along with the parents. They have moved a contempt against the parents before the learned trial court. How dare they come to Delhi when there is a direction not to meet? Now, no, 1 second. So, my lord, they cannot keep on changing their stance that once they are finding themselves in difficulty before this honorable court, the grandparents can be allowed.
No, my lord.
Then they will not
find that you do not have any objections.
I will do that, my lord, because please, what he's saying is completely incorrect.
Have you not filed a contempt, madam, against the grandparents? Please correct that.
We have
I don't make any
we have
such
not filed a
statements.
contempt.
No, don't.
So, Please file an affidavit
Yes.
stating that.
Yes, my lord,
That will be an
because
additional thing, my lord. Please, but Kolkata visitation is a
Kolkata-
separate issue.
the child cannot
Delhi
come
is
to
something
Kolkata,
different.
my lord.
Kolkata is different. No, Kolkata.
In May she has exams, my lord.
No, May I'm not.
And June is.
See, I am a responsible father appearing for him. If there are exams, I am not calling her for visitation, my lord, on 15th May. I will be requesting, my lord, your lordships in the final order to say whichever 3rd, 4th is the Saturday, my lord, Friday, Saturday. We have not met since February, March, April. Now we are entering May. 4 months I have not met, my lords. My parents have not met the child. What is the wrong in meeting the child, my lords, for Friday, Saturday? And there's absolute no inconvenience. Best of vehicle takes her from airport. Best of vehicle leaves her there. And children are resilient, my lords. With great respect.
Only grouse is the child being brought to
Deeply obliged.
Calcutta.
Deeply obliged.
Should I file an affidavit? I can do that.
I came running from 52 minutes.
106.
So just let the judge.
What happened?
Unless you mention something. Please.
Dismiss for default. What can be done? We are not present.
My lord, kindly make it not today, my lord. I came running from 652, my lord, by the time it was called.
106.
My lord, may I be permitted? 1, 2, 3.
My lord,
Sorry.
last occasion, lordship was pleased to pass an interim order which is expired on 30th.
But it is not mentioned in the morning.
Devnath Ghosh is Mr. Ghosh is appearing leading.
Maybe you could have mentioned in the morning, not now. Yes.
Item number 1 now. Item number 1, 2, 3. Last time it has been up to 120, but matter is extremely urgent. That is that regarding
item number
1, 2, 3 of the daily list.
123.
123.
Yes.
It's regarding to that sand mining. Last time Mr. Banerjee has mentioned the injunction order has been given.
Yes.
And for that,
so I could reach only up to 120.
That's why I'm mentioning, right? Can you
see what can be done? Because
any
all the groups have to be touched.
Any time has been fixed. This is a grave urgency.
Let me see. Because I'm trying to touch all the groups.
Well, kindly keep it
Tomorrow, please mention tomorrow.
Deeply obliged.
Thank you so much.